Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Justice Peter Sachs. To my right is Justice Joseph Ditkoff. To my left, Justice Robert Toon will be your panel for all 6 cases this morning. I want to extend a special welcome to folks from the firm of D'Ambrosio LLP in Boston. We have some interns and summer associates and regular associates, I believe, here today. And later on, we'll be joined by a group of interns from Beacon Hill working in state government this summer. If you've been here before, you know each side gets 15 minutes to argue. There's no rebuttal. We have read your briefs carefully. We've read the record. We're familiar with the facts and the procedural background of the case, so I would just urge everyone who's arguing today to get right to the heart of your argument. With that, we will start with the first case, 23P667, Commonwealth versus Sean McGinnis.
Good morning, Your Honors. May it please the Court, my name is William Corman, and I represent Mr. McGinnis in this particular matter. Respectfully, what we have here is yet again, in my opinion anyway, the Commonwealth exceeding all proper bounds in closing argument, despite the fact that there's cases upon cases upon cases which indicate what appropriate argument is. I recognize, as I have to, that trial counsel didn't object, and obviously we're using a different standard as a result of that. But nevertheless, respectfully, the question eventually becomes is, how long do we let the Commonwealth continue to make these what are clearly improper arguments without there being any sort of net result whatsoever? Case after case indicates that the Commonwealth acknowledges their closing arguments went above and beyond the bounds. They indicate that perhaps things were better left unsaid. They indicate that perhaps things could have been clarified better. And nevertheless, defendants are left with clearly improper arguments, which I would respectfully suggest taints their case. In this particular case, as the Court's more than well aware, there are a number of statements, I think there were half dozen statements, all along the same theme about whether or not my client, who was convicted of sexually assaulting his child, whether or not he broke some promise or some sacred covenant that takes place when an individual fathers children. Well, obviously, the crime that he was accused of and convicted of is reprehensible. We all know that. But for the Commonwealth to say over and over again that a father has a promise or to allude to a duty that a father has to their children to not sexually assault them, while on the street, that's a proper statement to make amongst individuals. It should go without saying. But to repeatedly say that over and over again to a jury during the course of closing arguments in a case where there was certainly contradictory evidence, I suggest goes beyond the pale. Obviously, he was acquitted of some of the charges, and that's something the Commonwealth says in their brief. And I would respectfully suggest that when the Commonwealth says, well, Mr. McGinnis was acquitted of some of the charges, therefore the jury understood what was going on and was able to accept the government's closing arguments as a mere rhetorical flourish, I would suggest that shouldn't matter. The fact that he's found not guilty of some charges doesn't necessarily mean that the government's closing argument didn't push the jurors beyond the pale.
I think, Counselor, that you need to wrestle with the fact that defense counsel used broken promises at least 6 times, broken promises, some subset of that, and actually said it was the theme of the defense closing argument. In light of that, is this really as bad as you're making it out as?
Well, I would respectfully suggest that there's a difference between the way the defense counsel brought it up. There was testimony that the victim in this matter was furious with her father because he broke promises to her to take her places. Clearly, the evidence was certain that Mr. McGinnis had a long-standing substance abuse problem, and she made reference to, breaking promises about not being there for her because he was drinking all the time. And the incident itself, he drank himself into a situation where she thought he died, quite candidly. So that's the context within which defense counsel talks about the victim being upset about the broken promises that Mr. McGinnis allegedly made to her, but he was also very clear that what he meant by the broken promises were, first of all, using her own words in a letter that she wrote and discussing the broken promises of essentially, you're going to stop drinking, you're going to be an attentive father, you're going to take me places that you say you're going to, you're going to participate in the parenting time that you've been allotted.
Was that letter exhibit the exhibit, or was the exhibit something else? Your predecessor said the exhibit said promises in it.
I think that, I don't know that I would have used the word exhibit. I think that it certainly came up during the course of the testimony, but off the top of my head, I don't believe it was entered into as an
But
exhibit.
there was an exhibit.
I'm sorry, Your Honor.
There was one exhibit introduced
Yes.
in this case. What is it?
I am going to have to refer to the brief, Your Honor. I simply don't recall, and I apologize for that. Regardless, I think the fact remains that there is a clear difference between the use of the words by defense counsel in his closing argument and then what the Commonwealth picked up and ran with. Anytime defense counsel makes any sort of statement during their closing argument, as long as it's a proper statement, I don't think it's appropriate for the Commonwealth to then take that and twist it into this mechanism which then is used to inflame the passions of the jury. So again, the mere use of a word doesn't give the Commonwealth a green light to then say, okay, I can now use that word in whatever context I choose, and in this particular instance, create what I would respectfully suggest is an improper closing argument.
I mean, it isn't the worst technique as a trial technique to use your opponent's theme and try to flip it on them, right? I expect you probably have tried this general strategy in your work in other trials too. So what makes this so inflammatory in your eyes? I mean, talking about a father breaking a promise to a daughter, what makes that so much more inflammatory than the actual allegations that were at issue here?
Certainly the allegations are inflammatory in and of themselves. There's nothing we can do about that. I mean, otherwise we never would have, I mean, that's what we're here for, right? Sure. What I would suggest is that the Commonwealth, in their closing argument, creates and reminds the jury over and over again of this, I think I used the word in my brief, the phrase, this sort of sacred covenant. This case wasn't about that. The case wasn't about Mr. McGinnis's attorney saying in any way, shape, or form, Mr. McGinnis is the paragon of fatherhood. And the fact that these charges have been levied against him is outrageous because he is the role model all parents should aspire to be to, which perhaps then could open the door for the Commonwealth to be like, are you kidding me? There's some sort of covenant between parents and children to sort of do no harm, using a phrase from the doctors would use. But that clearly didn't happen here. And the evidence is what the evidence is. But the Commonwealth then walks in and creates these sort of giant foundational blocks upon which society is built. The role of a father is to first do no harm to their children. There is this bond between father and child that Mr. McGinnis broke. And again, if it had happened once in reaction to defense counsel's statement about, the alleged victim here, or the victim here is going on about broken promises, let me tell you X, Y, and Z. But no, it's six times, I think it's a half dozen times, over and over and over again, just talking about this sort of, this philosophy, if you will, and I don't mean to be glib, but basically saying over and over again, individuals have an obligation to not do this. If this were any other crime, if this were a homicide case and the prosecution stood up and said, ladies and gentlemen, we're not supposed to kill people, that is, it's in the Bible, thou shalt not kill, and they talk about that over and over and over again in their closing argument, it has nothing to do with the evidence of the case. It's sort of the same sort of scenario here.
If I could direct your attention to the second volume of the transcript. At page 69, defense counsel is cross-examining the victim, asking her about when she spoke to investigators. You indicated that you didn't want to have a relationship with your dad because of all the broken promises. Is that correct? Yes. Okay, and those broken promises were that he would be the promises that you say he had made to you over the course of your life, that he'd be a better dad. Is that correct? Victim says yes. And you told the investigators that I don't need somebody like that in my life. And he would say, I'm going to change, and I promise. And you were mad at him because you felt as though he broke a promise to you. Answer, yes.
Correct.
Okay, so isn't it defense counsel who not only put it in the closing argument, but brought it out on cross that the victim felt like the father had broken promises to her that he would be a better dad? So how is it beyond the scope of the evidence to argue that in the Commonwealth's closing?
What I would suggest, Your Honor, is that it's the contextual statement of the Commonwealth in their closing argument. They don't build upon or they don't refer to what defense counsel said during his cross-examination of the victim in this case. Again, as I said before to Justice Toon, they're creating these sort of maxims that the jury should acknowledge and therefore convict upon. And it would be one thing if they continually referred to that evidence when they were talking about the broken promises, but instead they're creating, again, apparently glib is my word of the day, without sounding glib, they're creating these slogans by which the jury should follow, which has nothing to do with this case. And that's, in my opinion, when it crosses from proper to improper.
The defense theme was, as I recall, the victim, did this letter where she talked about all these broken promises, but didn't mention the alleged assaults. And so that was sort of evidence that supported the defense position here, right? And
there were contradictory statements to the investigators.
Sure. So but just in terms of why was the defense talking about the broken promises, right? Well, you've all these broken promises, but you didn't mention the things that we're talking about here at trial.
Correct.
So that's why it was such an issue for the defense to raise during closing. And is your concern that the rhetorical flourish that the prosecutor used sort of overwhelmed that point about the lack of any allegations in the letter as to assault? I just trying to make a connection here.
I'm certainly not going to concede that it was a rhetorical flourish. I think maybe one use of that phrase may have been a rhetorical flourish.
Rhetorical framework, maybe.
I think here what it really was an effort to, gild a lily that perhaps didn't need gilding. And by referring over and over again to, parental obligations in this, I would suggest, inflammatory way, that's the problem. If there are no further questions, I'll rest upon my brief. Thank you very much.
Seeing none, thank you. We'll hear from the Commonwealth. Mr. Kidd.
Yes, good morning, Your Honors. My name is Rob Kidd. I represent the Commonwealth in this matter, Bristol County DA's office. I believe as Justice Discoff had pointed out and Justice Sachs, the defense counsel, the prosecutor was in this case responding to directly to a theme of the defense counsel's argument. In his closing argument, defense counsel said, he quoted from that letter, he said, when people don't live up to their promises, she, the victim, gets upset. So much so in April of 18, you heard testimony from the victim. She wrote that letter to her dad saying, I don't love you, I hate you, you've broken your promises to me, you're not a good dad, you're not a good dad, I don't want to be around you because you don't do things with me, you don't take me places, you don't go anywhere, you drink too much, you've broken your promise to me. That's what he says in closing, and as was pointed out, he says he makes that a theme of his closing argument. The prosecutor, when she heard that, seized on that and responded to that, and the first thing she said was, let's talk about promises. And she did talk about the implicit promise of a parent to his or her child. She did say that a number of times. It was a rhetorical flourish, and the reason it was is because it's a statement that is, as I said in the brief, it's a truism. It's in the sense that everybody in the world in this courtroom knows that the first duty of a parent is not to harm his child. I think she used it like sort of a punctuation mark in the first part of her argument. And by the way, she used it in the very first part of her argument. It takes up about a page and a quarter of testimony, but her closing argument, the prosecutor's argument, was 6 pages. So after she uses this flourish, which is after every incident, there's 3 incidents. There's the couch incident. She describes it, and then she says, father's duty is first to do no harm. And then she goes into the evidence, and she goes into the evidence and responds to the very vigorous attack that the defense counsel made on this child's credibility, properly pointing out the inconsistent statements that she had made to the investigators. So we maintain that this is a rhetorical flourish because the jury would not have understood, the jury would not have made the logical conclusion that because there is a duty, a parental duty, therefore this defendant must have done it. As the courts say, jurors are attributed with a certain degree of sophistication in these things. And as the court knows, there were 3 charges that the jury considered. And as I said in the brief, they did take some time in their deliberations. They did ask a question of the judge. They asked the judge, what they needed to find in order to find the defendant guilty. They went back. I think there was 4 hours maybe of deliberation, and after that question, and then they acquitted the defendant out of 2 out of the 3 charges. The Commonwealth would suggest...
Mr. I agree that the fact that there was a partial acquittal supports the argument that the jury wasn't swept away by these remarks. On the other hand, I think Mr. Corman makes a good point. You can't just say that it's a rhetorical flourish. This is a theme that went through the entirety of the closing. I think she mentioned the word promise 8 times during her closing. So it was kind of suffused through the entire argument. And I guess, what my concern, I think, is a point that you made in your brief, too, is about that the rhetoric was arguably designed to kind of overwhelm the point that the victim didn't list the alleged assaults in her letter describing the defendant's failings. And could you just address that? Why isn't that a problem?
I think what you're saying is that was defense counsel's theory, right? The defense counsel's
That was
theory.
defense counsel's theory, and the prosecutor didn't really respond to that point, but just sort of used it as a kind of rhetorical bludgeon to sort of, so is there a problem there about kind of not missing the point of this evidence and using it as a rhetorical framework instead?
I think that she was, I don't think she necessarily, she didn't, that wasn't respond. I agree that it was not responsive to that particular argument. It was just a mechanism that the prosecutor used to enhance her argument, or it is a rhetorical thing that makes the argument sound better. It's sort of like a repetition in speeches is something that people do. She didn't. Yes, I agree that that was not responsive to the defense counsel's argument. It didn't go right to it. But in the context of the argument, and Your Honor said that the prosecutor used this as a theme throughout her argument, I respectfully disagree. It only, as I said, is a 6 pages of transcript. Yes, she said it 6 or 8 times, but it's at the very beginning of her argument. And then for the next 4 pages, she just goes on and talks to the jury and tells them why they should believe this child, all the consistent things this child said. So in the context of her argument and of the trial, I don't think that it was improper in the end. And let me just quote for you from the case of Commonwealth versus Avila that I have in my brief, Avilas, which is a child sexual assault case. And here's what the prosecutor said. What was bad, what was shameful, he said, quote, what was bad, what was shameful, what was criminal was this man's conduct, the defendant. This man's conduct in betraying his wife, his family, and a little girl that trusted him. This man's conduct in raping her and molesting her day after day. They found that comment was questionable, and they said it's perhaps it was, but in the end they considered it to be hyperbole or rhetorical rhetoric. The facts, the statement that is in this case is much, much less emotional and egregious than that. And I would point to also to the defendant's brief. I think on page 17 he lists some cases which he says are examples of the court taking disfavor on going over the top in these types of cases that exceed the bounds of rhetorical flourish. I'm sorry, it's page 14 on his brief. There were 3 cases he cited for the proposition that closing argument presented in this case at bar reflects the kind of unnecessary and hyperbolic embellishments appellate counsels traditionally view with disfavor. He quotes Commonwealth versus McCoy, Commonwealth versus Macello, and Commonwealth versus Ciampa. In McCoy, Your Honors, what the prosecutor did is he tried to smear the defendant with his association with drug dealers. He cross-examined the defendant, and because the defendant had testified about what his activities were that night, and he said who he's with, and then the prosecutor named those persons and said, "Oh, don't you know that so-and-so has a record, does she not?" Objection, but the objection is overruled. So then he goes into his closing argument, and in his closing argument, the prosecutor points out that this defendant was hanging out with so-and-so who was convicted for such and such, so-and-so who was convicted of such and such. That I suggest you suggest to you goes way over the top. It's smearing the defendant with being with drug dealers. Has nothing to do with the case. That's a case, clearly. And then the next case he cites on page 14 is Commonwealth versus Macello. Commonwealth versus Macello is a case where the prosecutor, is a murder case where the prosecutor in his closing argument basically tried to read the defendant's mind, and he said something like, I'll tell you what this defendant was thinking. This defendant was thinking, if he's not going to get out of here, I'm going to kill him and take him out of here myself, or words to that effect. So he was reading the defendant's mind and attributing a motive to the defendant. So these are different, so this is not in the class of cases that we traditionally see of a prosecutor going over the top. I'm not unaware that it does happen, and people get carried away in closing arguments, and people say things that they shouldn't say. I don't think this is one of those cases when you look at it from, all the perspectives. And when you go through the prejudicial part of it, the substantial risk test, they talk about, whether the objection was made. There's no objection here. Whether it goes to the heart of the case, right? It doesn't go to the heart of the case. A father's promise to his daughter does not have any bearing on the defendant's defendant or the victim's credibility, and the jury would not have seen it that way. Whether the result would have been different had the comment not been made, I don't see the result being different. The jury acquitted him out of two out of three charges. So you're going to say that if he hadn't made this comment, they would have acquitted him of all the charges? Or if she hadn't made this comment? I don't think that's the case. So when you use the factors, even if it was over the top, the factors for substantial risk certainly weigh in favor of the Commonwealth. And that's probably all I'm going to say. If the court, unless the court has any other questions, I'll rest on my brief.
Counselor, would you be able to get us a copy of the exhibit?
Sure.
That would be helpful.
Sure. I think it's Exhibit 1. Yeah.
I think there's only one exhibit, but the text messages.
I will do that.
Thanks.
Just mail. Should I just mail that in? Or file it? Should I file it?
Yeah. File it with the use the e-filing system.
Thank you.
All right. Thank you very much for your arguments. Our next case is 2020 P857, Commonwealth versus Austin Waite.
Good morning, Your Honors. May it please the Court, Joseph Smith on behalf of Mr. Waite. Your Honors, this is a case that essentially presents a Guardado issue. So in the wake of Commonwealth versus Guardado 1, the SJC announced a new rule or new constitutional precedent that a requirement or an essential element of the offense of carrying a firearm without a license is proof of lack of licensure. So of course, this case, at trial, the trial judge did not instruct the jury that an essential element of the offense was that the Commonwealth was required to prove beyond a reasonable doubt that the defendant did not possess a license to carry a firearm. So my argument here is twofold. One, in the wake of Guardado 1, the Commonwealth moved for reconsideration because the initial holding in Guardado 1 was that where this instruction was omitted, with this jury instruction, the remedy was vacatur of the conviction and an entry of a required finding of not guilty. Guardado 2, in some sense, changed that precedent insofar as the court ruled that double jeopardy doesn't necessarily attach and that a required finding isn't the necessary remedy in general when the instruction's omitted, that the remedy ought to be the awarding of a new trial for the defendant. But that case, the holding in that case really rested its opinion on the idea that the Commonwealth was not on notice at the time of the initial trial that a new constitutional rule essentially was going to be announced. And that's true as far as it goes, but I think that Guardado 1 and 2, the case law surrounding this issue itself still remains somewhat unsettled, or the contours of those cases are still undefined in many respects. And one way I think it remains undefined is in the context of this case. So in terms of my argument that a required finding should still enter, what we have here in terms of the facts of the case, it's a motor vehicle stop, as your honors are aware, and I'm generalizing here, but at some point, Mr. Waite, who's seated in the passenger seat of this vehicle, is ordered out of the vehicle. He exits the vehicle. The police notice that he has a holstered firearm in his waistband. And in response from the officer for a demand to see his license to carry a firearm, Mr. Waite allegedly indicates that he did not have one. But this is testimony that's elicited by the Commonwealth. And it begs the question, if the Commonwealth in this context, in this case, was not on notice or did not sort of anticipate that there may have been this new rule or that this constitutional shift was potentially on the horizon, then why would they have elicited it at all? There's no evidence in this case that the Commonwealth was put on notice by Mr. Waite of a potential affirmative defense, which would have been the way in which you would raise it at the time for lack of licensure.
Does it matter why the Commonwealth introduced the evidence? Are you suggesting the Commonwealth did know that the Guardado rule was coming?
Well, Your Honor, why else would it be elicited? Is my
well, why does it matter why the Commonwealth elicited that evidence? The question before us, I think, is what is the significance of that evidence after Guardado 2 and after Bookman?
Right. So my answer to your question, Your Honor,
doesn't the defendant's admission that he did not have a license render the omission of the instruction to the jury harmless beyond a reasonable doubt?
Well, that's a two-part question. I'll answer the first part of your question first, chronologically, if you will. So in terms of your question regarding, am I arguing that the Commonwealth in this case knew that this decision was essentially coming down the pipe? You could make the inference that in this context here, yes, because why else would they elicit the testimony? Because there's really no other reason where to the extent we accept the proposition that the Commonwealth's entitled to the clairvoyance exception, if you will, because they had no idea that this ruling was coming down the pipe, okay, that's fine. But in this case, you could make the argument that the Commonwealth opened the door in the sense that the only reason they would have elicited this testimony is because the inferences they anticipated that they may need to preserve a conviction to the extent that the law changed and a licensure requirement was ruled to be a proof of lack of licensure was ruled to be an element of the offense. So in this case, I think that the court can make the determination because of that, because the Commonwealth elicited this testimony. Contrary to the general holding in Guardado 2, a required double jeopardy should attach because the Commonwealth sort of presented evidence that would lead a reasonable, appellate court to make the determination that they were on notice in this context. And so they shouldn't be entitled to say, well, we really didn't know, the clairvoyance exception should apply, and we should be allowed to retry the case. But even to the extent the court doesn't accept that argument, I think that this evidence is not harmless beyond a reasonable doubt. We have here an uncorroborated confession. Well, we have an uncorroborated confession without more. There's no other evidence of lack of licensure in this case. So we don't have testimony. And this case is, I think, distinguishable from Bookman, which is a case that the Commonwealth heavily relies on. So in that case, and in its companion case, Acevedo, I think it is, a reading of those cases, the facts related to that specific issue, the lack of licensure, are somewhat unclear. So in Bookman, the recitation of the facts related to that issue in terms of lack of licensure is that an officer testified that the defendant didn't have a license to carry a firearm, and that it was uncontested. Well, that also begs the question, well, how did the officer know that the defendant in that case did not have a license to carry a firearm? So it doesn't appear that we have a confession, if you will, from Bookman or the co-defendant. So the presumption would be that a database was searched, and in some sense, the defendant's name was not present pursuant to that database search. So we have here an issue where the corroboration rule, I think, applies in both aspects of my argument.
So you're saying that there needed to be corroboration that he wasn't licensed?
Correct.
So what do you say to the Commonwealth's reliance on Commonwealth versus Costello, which says that the corroboration rule doesn't require corroboration of each element of a crime.
So yes, Your Honor, that in my view, that language in Castillo is essentially quasi-dicta. The court really didn't rest its holding on that at all, and in fact awarded the defendant, in that case, a required finding of not guilty. But I think it's fact specific. So in Castillo, the court relied on Ford, and in Ford, the facts of that case were that because the victim, if you will, was deceased, that was corroborating evidence of a homicide. But this is a far different factual circumstance or type of crime. So the crucial element, in my view, with respect to carrying a firearm without a license, is the lack of licensure. Because as the case law tells us, and as Guardado has sort of expanded upon, carrying a firearm in Massachusetts is not a crime. It's carrying a firearm without a license that is a crime. So where we have no other evidence of illegal possession, for example, or any other sort of...
There being a dead body isn't a crime, but a dead body plus a confession is enough for a murder conviction. Why isn't that the same?
Fair enough, Your Honor. I think it's hard to sort of it's hard to group every single separate offense into this sort of into this framework. But in a case like Commonwealth versus Leonard, that was a case where the crucial element that wasn't corroborated was operation of the vehicle. So, and that's a case that deals with the corroboration rule as well.
How do we decide which element is crucial and which element is not?
I think
they all have to be proven beyond a reasonable doubt, but
Yes.
not all of them require corroboration.
Correct. Well, I think again, that language.
There just needs to be some corroboration that a crime was committed.
Right, and so, but my argument is that the language in Castillo is sort of, it's quasi-dicta, and Ford really, I'm not sure, says explicitly what the Commonwealth describes that it says. But I think here, where we're talking about possession of a firearm without a license, that the crucial element is the lack of licensure. And where there's...
Don't think the crucial element is possession of the firearm?
Well, I mean, again, because of the fact that carrying a firearm in and of itself is not a crime. So I think that, in
But usually you wouldn't start a firearm carrying prosecution by checking whether someone had a license. You'd start with a firearm.
well, I think that's certainly part of a firearm investigation would be lack of licensure. At the very outset, when a police officer is going to make an arrest for a firearm offense, you oftentimes see that an officer makes an inquiry, makes a database check. There's some sort of inquiry into the licensure status. There's not simply any time that there's a firearm presented on a person's waistband, in a holster, by the way, with a defendant that's not brandishing the weapon, not uncompliant with the police. There's no evidence that the defendant's history was one which would suggest that he was ineligible for a license to carry a firearm, prior criminal convictions, gang affiliations, and so on. So, yes, I think it's hard to parse out these things and say, even though I'm sort of making the argument that there's a crucial element that needs to be corroborated in certain cases, I think here, where there's an uncorroborated confession as to licensure, that is important.
Isn't the purpose of the corroboration rule to sort of avoid people being convicted for imaginary crimes, right? I mean, that was
Yes.
what they talked about in Ford. But here, it's a very clear, it's not an imaginary crime. It's unlawful possession of a firearm without a license. And so I'm not sure if the rationale, even if we were to sort of say corroboration requires corroboration of particular elements, the whole logic of that rule doesn't really seem to apply here. It's just a really discrete factual question. Did the defendant have a license or not? And he admitted that he didn't, and that seems pretty solid evidence to support that.
Well, I mean, you are in Leonard, which is another leading case dealing with the corroboration rule. It was an OUI investigation, and they can certainly corroborate the fact that the defendant, who was the alleged operator, was intoxicated. They simply couldn't corroborate that he was operating the vehicle. So, to what extent? And I believe, based on my recollection of Leonard, the other suspect that could have potentially been the driver may have also been intoxicated. So, one could infer that there was not I agree with Your Honor that the corroboration rule is designed to protect folks from being convicted against imaginary crimes. But certainly if someone, for whatever reason, based on an aberration or based on the factual circumstances, stress and so on, gives an equivocal answer in response to a demand to produce a license to carry a firearm, I think the corroboration rule could be implicated. And I know it's splitting hairs to some extent, but when you're involved in a motor vehicle stop with 12 police officers sort of aggressively ordering the folks out of the vehicle, it's a demand to produce a license to carry a firearm. The defendant indicates, I don't have one. Again, perhaps I'm splitting hairs, but I don't have one could potentially mean I don't have it on me, but nevertheless, maybe I have one. So there's, in the context of proof beyond a reasonable doubt, I think that's important. And so if there are no further questions, I would rest on my brief.
I do have a question.
Yes, Your Honor.
We stayed this case for 2.5 years for a public records request. What was that about?
Your Honor, I was investigating a potential motion for a new trial related to police internal affairs records that took a very long time to obtain. And after a much litigation with respect to the Secretary of the Commonwealth's office and otherwise, I was able to obtain the records, and then when Guardado came down, it presented a clearer path.
I was wondering why it took so long, but internal affairs records, that answers my question.
It was a bit of it was tough sledding, let's say, Your Honor. And again, if there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
We'll hear from the Commonwealth. Ms. Martinelli. Whenever you're ready.
Good morning. May it please the court, Jacqueline Martinelli for the Commonwealth. I'm asking this court to affirm the defendant's conviction. First, the evidence presented at trial was sufficient to establish that the defendant lacked a license to carry a firearm. Officer DePina in this case testified that after he recovered the loaded firearm from the defendant's waistband, he then demanded the defendant's license to carry, to which the defendant replied, I don't have one. This testimony was not objected to, and the subject was not explored during cross-examination. So under Bookman, and in the light most favorable to the Commonwealth, this was sufficient to establish that the defendant lacked a license to carry. Second, the failure to instruct the jury on this new element was harmless beyond a reasonable doubt. This error would not have affected the jury's verdict, as it was simply not an issue in this case. Again, the only evidence presented was that the defendant lacked a license to carry. Additionally, again, this was not objected to, and it was not a subjective cross, and the defendant in this case had a very clear theory of the case. And the defendant's theory of the case was presented not only through cross-examination of multiple witnesses, but also during closing argument and opening statements. The defendant's theory was that the driver of the motor vehicle was the person that had the gun, and it was a game of hot potato, and it was passed to the defendant. So again, under Bookman, the error in failing to instruct was harmless beyond a reasonable doubt.
I understand the hot potato point, and that was the closing argument by the defense. But that's not evidence. Is there any other evidence establishing the absence of a license other than the statement that Officer DePina reported that the defendant made?
The only evidence about the license to carry was that statement by Officer DePina.
What's your understanding of how the corroboration rule applies to elements?
So the corroboration rule, as Your Honor did state, is the purpose of it is to prevent imaginary crimes. And here, it's just simply not the case when the defendant was arrested with a loaded firearm in his waistband. And again, as this was mentioned
about... But that's only a crime if he doesn't have a license.
Correct, Your Honor. And I think maybe a situation perhaps where the defendant maybe walked into the police station and said, hey, I have a loaded firearm, but I don't have a license to carry, and there's no firearm that's recovered. That perhaps could be an imaginary crime, but when you have here a defendant with a loaded firearm in his waistband, there is no imaginary crime. A crime did occur. And as Your Honor stated under Commonwealth v. Costello, the corroboration rule does not require every element to be corroborated.
But again, how do we know a crime occurred unless we know that he wasn't licensed?
Well, in this case, again, the firearm was...
I mean, this is not a dead body that has ligature marks around the neck or bullet wounds.
Correct, Your Honor.
Which would be indication of a crime.
Correct, Your Honor. And the statement that he doesn't have a license to carry obviously does establish that he doesn't have a license to carry. But still, the corroboration rule does not require every element. And in this case where there...
It doesn't require every element as long as it as long as there's evidence that a crime was committed.
That there's some evidence,
And
yes.
so, for example, where you have a dead body with bullet wounds, you know a crime has been committed, even if you don't know that the defendant did it, even if you don't know with what intent it was done. Obviously, you don't have all of the elements of a first-degree murder conviction just from discovery of the dead body with the bullet wounds. Where you have a person with a loaded gun, how do we know just from the possession of the loaded gun that any crime has occurred?
We could also look at where the firearm was recovered. It was not in a locked safe or anything. It was in the defendant's waistband in a holster.
Is that a crime?
Well, there could be a crime in terms of carrying a firearm not in the proper procedure in terms of making sure it's safe in a safe.
But was that what he was charged with?
That was not what he was charged with, Your Honor. He was charged with unlicensed possession of a firearm, loaded, and ammunition.
Do you think there was sufficient evidence to convict him of some other offense based on the firearm here?
Potentially, there could have been I believe it could be a fine. There's a fine, but I'm not sure if there'd be a criminal charge, Your Honor. But I would just also point to Commonwealth v. Taft. It's an unpublished appeals court decision where it was the exact same scenario as this case, where the officer testified that the defendant stated that he did not have a license to carry a firearm, and the appeals court determined that that was an error harmless beyond a reasonable doubt, which is the exact same fact pattern that we have here.
Is that Taft, like the President Taft? What's the name of the case?
Yes, it's Commonwealth v. Taft.
How do you spell it?
T-A-F-T.
Okay, thanks.
And finally, just turning to the double jeopardy argument, again, Guardado 2 did make it clear that double jeopardy does not attach to this case. So in the alternative, we would ask that this case be remanded for a new trial. If there are no additional questions, then I would rest on my brief.
All right.
Thank you.
All right, our third case is 23P585. I'll call it Commonwealth versus a juvenile. It's listed as impounded. Not sure that that's correct, but we'll play it safe and ask the parties just to refer to the juvenile as the juvenile, no names. So, Mr. Stelmack, whenever you're ready.
Good morning. May it please the court, Jason Stelmack for the juvenile who was 14 years old, was a backseat passenger in a motor vehicle, stopped for a minor civil motor vehicle infraction, a non-arrestable offense, and the officer asked for, requested or demanded the identification of the 14-year-old in order to unlawfully and mistakenly write him a citation for failing to wear his seatbelt. My argument...
Was it unlawful to ask him for identification to establish his age?
Yes.
Why?
And because under Torres, when there's a motor vehicle stop for a minor civil infraction, focusing and investigating a passenger without reasonable suspicion, without probable cause, is unlawful and a violation.
Well, no one had a seatbelt on, if I recall.
I'm sorry?
No one had a seatbelt in the car.
Right.
Is that correct?
That's correct.
So what's wrong with establishing their identities so that the officer can issue appropriate citations? Granted, in this case, the officer did not issue an appropriate citation because the juvenile was under 16. But what's wrong with finding out who they are and what their ages are in order to issue proper citations?
Because under Torres, the court says that you cannot focus or stop or continue a detention of a passenger who has not violated the law.
Well, now, hold on. Where was the detention of the passenger? I didn't see that anywhere in this evidence.
So, I mean, he is stopped. He is
The car gets stopped, but everyone agrees the car stop is fine.
Right.
But he's perfectly free to wander off if he wants to.
And that's the point. So when the officer focuses his attention to him and asks for the identification, that is where he, as a reasonable person, would not be.
Well, I don't understand why that's a seizure. There's plenty of case law that says that officers can go up to people, talk to them, ask them questions, ask them their name, ask them their date of birth. So why is doing that a seizure?
Because under Torres, it's specifically the court says you cannot do that. You cannot, when the focus of a stop is a motor vehicle infraction of the driver who committed that infraction, the focus on a passenger who has done nothing wrong, nothing illegal, because this juvenile did not do anything illegal. He did nothing wrong. On this statute, he has no obligation, the driver does, to make sure that he is wearing a seatbelt.
I thought you conceded in your brief, it's without question that an officer can request identification to issue a citation to a passenger if that officer has probable cause to believe that the passenger failed to wear a seatbelt in violation of Chapter 90, Section 13A.
Absolutely. And so under that statute, only if you're 16 or older.
So the officer didn't know, did he?
Yes. There's no
He
indication.
didn't
there's no
know whether the
evidence.
passenger was over 16 or over or not.
No,
Could he request identification in order to find out whether he should issue the citation to the passenger or the driver?
if there's a question. If the officer has a question as to the age and it's reasonable to say, you look 16, you look
Okay.
17.
So was there a reasonable question here?
No.
You think we should find as a matter of law that there was no reasonable belief that the juvenile was 16 or over?
There are no facts in the record to suggest the officer.
What about the booking photo and the weight and height?
Exactly. The booking photo shows that this is a child.
Well, does everyone agree on that?
Well, that's what the evidence is. There's no evidence that the officer believed that he was 16.
Well, it's not a question of the officer's subjective belief. It's what an officer could reasonably believe. Could no reasonable officer, indulging the reasonable inference that the juvenile looked the same in the car as he did in the booking photo later in the day, could no reasonable officer think that that person is 16 or over?
I mean, that is just simply not in evidence. So,
Well, if the parties stipulated, did you assert to the judge that there was a question of fact as to whether the juvenile could reasonably be thought to be 16?
no, because, again, the evidence, the police report is the findings of fact, essentially, and there's nothing in that police report where the officer said, I had a reasonable belief that the person was 16.
But does it matter what the officer says? Doesn't it matter what the evidence is, what a reasonable officer could believe, not what this officer subjectively believed? Isn't that the standard?
Correct, but I think there has to be some evidence of that.
Okay, so could not the officer reasonably believe, based on the appearance of the juvenile in the photo, that he was 16 or over?
I don't believe so. And then, again, when he is...
And you think the assistant DA will agree as a matter of law that no reasonable officer could think he was 16 or over?
I can't speak for her, but I think she can agree that there's no evidence to support the belief that this officer had that belief. And again, the fact that he issued the citation to the 14-year-old is just proof that he didn't know what the law said. So
To go back to the seizure, I looked at Torres, and in Torres, the officer actually takes Torres's wallet, so that's a seizure. But here, where it's just a question, and then your client could have wandered off if he wanted to at that point. How is your client's detained at all?
So again, once he's asked that question, and the Commonwealth phrases it as an investigation of a civil infraction, I think that is when my client has a reasonable belief that he's not free to leave, because the officer is focusing his attention on my client and making demands for his identification. That's when the violation occurred. And so I think that's the point, is my client was not free to leave once the officer was asking for and demanding the identification.
Can we move on to your argument about
Sure. Can I
sentencing?
just make one last point? Because the Commonwealth and the motion judge draw no bounds to this sort of request. So in the seatbelt statute, there's a reference to Section AA, which deals with 8-year-olds in child seats. And so just sort of how far can the police go in terms of...
Right. Well, can we, since this is documentary evidence, the police report with the photo, is there any difficulty with us looking at that photo and deciding whether a reasonable officer could believe that the juvenile was 16 or over? I mean, we don't like to find facts at the appellate level, but documentary evidence, we don't owe deference to the motion judge.
Again, I would just say that there are no facts and evidence that suggest that the officer believed reasonably or objectively, subjectively, whatever the standard is, that this individual was 16 years old.
So on your argument about sentencing,
Yes.
and you assert that the judge did have discretion to sentence the juvenile to commitment to DYS for a period less than until his 21st birthday. And 58C says that the commitment to DYS until the 21st birthday is the least severe of the three options for youthful offenders. So Chapter 119, Section 52 defines youthful offender, and it says that it's a person who's subject to an adult or juvenile sentence for having committed, while between the ages of 14 and 18, certain enumerated crimes or described crimes. And then at the end it says, provided that nothing in this clause shall allow for less than the imposition of the mandatory commitment periods provided in Chapter 119, Section 58. So my question is, what mandatory commitment periods is that definition referring to in Section 58 for youthful offenders, other than the one that's at issue here?
So there are a few mandatories in Section 58. There's the firearm offense where you have to be detained or committed to DYS for a certain amount of time. So that's one.
We're talking about mandatory commitment periods for youthful offenders.
Okay, and then I would say paragraph B, the language is much stronger, that it's a mandatory because the legislature used the word shall, whereas in paragraph C, a common sense reading of that is that the offender may be committed up until his 21st.
So in B, you're referring to the language that says a combination sentence which shall be a commitment to DYS and an adult sentence?
Correct.
Isn't that easily understood, that shall, as merely a way of introducing the definition of combination sentence, which is not defined or used anywhere else in the general laws that I could see?
I think it can be read that way, but I think, the rule of lenity in reading it in the juvenile's favor, I would argue that section could be referring to paragraph B.
Okay.
Go ahead.
Counselor, I noticed you quoted Commonwealth versus Terrell 3 times in your briefs, but you never explained why it's not controlling against you. I'd like you to do that.
Right, I mean, Terrell, it's not, it doesn't directly address.
Terrell says that a judge can't decrease it even a few days less than 21. So how could he decrease it years less than 21?
Well, Terrell deals with credits. So if he had been held in DYS, the court said that he's not deserved credit like adults are.
Credits, which would mean that his commitment to 21 would end before he was 21. They
Right.
said that's illegal. So you want the judge to, instead of decreasing it a few days from 21, to decrease it years from 21. So how does that work with what Terrell says?
So Terrell is dealing with the sentence and saying that if the commitment is until 21, you can't give him credit and take any days off of that. I'm arguing that the commitment doesn't have to be until 21. And so a judge can commit until 20. So I don't think Terrell is controlling on that issue. And interestingly, in this, I didn't realize it when I was writing the brief, but the Section 58 language where it talks about probation uses the exact same language as it does in paragraph C. It says that a person can be, a delinquent juvenile can be placed on probation until the age of 18. Now, that has never been interpreted to mean that every juvenile that receives a probationary sentence in juvenile court must be until the age of 18.
Where is that language you're referring
That's
to?
in the first few sentences of Section 58.
Are you talking about the language that says if a child is adjudicated delinquent child on a complaint, the court may place it on file, place the child in care of probation officer, or may commit him to DYS, but the probationary commitment period shall not be for a period longer than until such child attains the age of 18?
It's that any such probation may be imposed until such child reaches age 18, or 19 if the case is still open until 20.
Okay. So, well, the language I'm reading, I just want to make sure we're literally on the same page here, is the probationary or commitment period shall not be for a period longer than until such child attains the age of 18.
No, so I'm referring to, I think it is I think it's still the second sentence of section 58, where it says that, talking about probation, that any such probation may be imposed until such child reaches age 18 or 19. And it really places the limit, the ceiling, the jurisdiction of the juvenile court and DYS as to those ages. And it doesn't, I would argue, make it, again, a minimum mandatory period of probation until the person is 18, because that would nullify any type of 3-month, 6-month, 1-year probation in the juvenile court. And so if you were to adopt the Commonwealth's interpretation of that language, ultimately that would have to be the result, that there's no more probation in juvenile court that ends prior to the person's 18th birthday.
Could you talk about the Dones case? And you rely on the reasoning of the Supreme Judicial Court to support your position, but what about the actual holding? Could the judge in this case have suspended the commitment here?
Under Dones, yes.
But that wasn't asked for. Is that because Dones was decided after?
No, I mean, my client had been committed for another case, separate and apart. It had to do with the warrant for which he was arrested. So that case, having a suspended sentence on this case just didn't make sense. But to answer the Dones, I mean, Dones is great that it says that unless it says that you can't do it, a juvenile court judge can do it. And that's exactly the argument that I make here. It's not expressed that the judge cannot commit.
So you don't find the actual possibility of suspension to be helpful to your client in this case? Just the logic of the decision?
Right. No, I don't think that it would apply. I mean, obviously, he would have the option to ask for a suspended sentence now, but...
So right before the language in 58C that you're relying on is the language that I was reading out loud before that said if a child is adjudicated delinquent, the court has various options, including custody of DYS, but the commitment period shall not be for a period longer than until such child attains the age of 18. If the legislature had meant to confer discretion on a judge to commit a youthful offender until not longer than his 21st birthday, wouldn't the legislature have used similar language?
I mean, I wish they had used that language, but I don't think that it means that. Because we know that the legislature knows how to create minimum mandatory sentences, and that the no less than is not in paragraph C. Thank you.
All right, seeing no further questions, thank you for your argument. We'll hear from the Commonwealth, and I'm not going to, Sikanalfi, I'm going to guess.
Good morning.
Thank you. Good morning.
May it please the Court, Kyle Sikanalfi for the Commonwealth. Asking this Court to affirm the denial of the motion to suppress and the sentencing order in this case. Turning first to the stop, it's not in dispute that there was a lawful basis to conduct the stop. It's not in dispute that the length of the stop was appropriate, commensurate with what was transpiring. And it's not in dispute that the 3 occupants of the vehicle were not wearing their seatbelts. The real question that was posed to the motion judge and raised again on appeal is whether officers were precluded from learning the identifying information of the juvenile in the backseat for purposes of issuing a citation. And here, where the officers had lawful basis to issue that citation either to the juvenile himself or to the driver, depending on the age under the law, they properly sought the identification information, learned of the active warrant, engaged the arrest, and found the firearm on his person.
Is there any evidence, basis in the record to conclude that the officer believed that the juvenile was 16 or older?
The record's silent on this officer's subjective belief.
And he didn't do a record check to find out the juvenile's age, because clearly he did not understand the law in this respect, right? Because he ended up citing the juvenile for an offense that doesn't apply to people younger than 16, right? So you're saying the purpose of doing the record check was to what exactly? If it wasn't to ascertain the juvenile's age, what was the purpose of the check?
I think it's reasonable to infer that it was for verification of the age that the name and age that the juvenile provided, and in doing so, encountered the fact of the active warrants.
Why would he need to know the age if he didn't understand the fact that this citation can't be applied to someone younger than 16?
For purposes of issuing the citation, he learned the name and age or date of birth for this juvenile. And it's not clear whether that was provided in the form of a state ID of some sort or verbally reported by the juvenile himself. But with that information, what we can infer from the record is that the officer sought to verify it and encountered the active warrant for the juvenile. Now, the fact that the officer issued the citation to that named juvenile rather than to the driver, that was improper. We know that that's an invalid citation, but that doesn't mean...
This is what I don't understand. I mean, the problem here, of course, is that you guys put the police report in here. It doesn't tell us anything about how this actually happened and just put that as the evidence. But if you have a name and a date of birth of someone who is too young to have a driver's license, or even a school ID card, what is the police officer checking? Does the MDT attach to all the school systems, or?
Well, it may well be that there are not results yielded, but why should that possibility preclude an officer from verifying reported information?
My question is, if someone says, I'm under 16, here's my name, here's my date of birth, what can you verify on that MDT?
For example, as here, the fact of their identity. And I would submit, we're stepping outside of what information was before the motion, Judge, but I would submit that juveniles who are ages 14 and over who have a state ID, that information would be in the RMV and CJIS terminal, because that's how the state assembles its records of individuals with identification that aren't, even if they're not motor vehicle operators. So,
Are there addresses in there?
I'm sorry?
Are there mailing addresses, home addresses in there?
As it would be represented on the state ID, yes. So that is in a manner of affecting the citation.
Does the RMV issue IDs to people younger than 16?
Yes, my understanding is that it begins at age 14 that you're eligible. But I think the point is the request of the juvenile to produce his identifying information was in reasonable furtherance of issuing a citation. The fact that it was erroneously issued to the juvenile himself and not to the driver doesn't upend the fact that the officer was in lawful performance of his duties when he learned the information.
Can you just tell me,
You're right.
well, why does a 14-year-old have a record with the RMV? I mean, I understand if you have a permit, you can get it when your last months of being 15, but why are 14-year-olds?
Maybe I'm misspeaking by characterizing it under the umbrella of the RMV, and again, I am...
No, you're right. The RMV issues ID cards to people who are 14.
And I think it's maybe...
Didn't know that till just now.
A pipeline to their operating of motor vehicles at a later date, but for even adults who don't have operators' licenses, who have state IDs, their records are attainable through the registry of motor
But so
vehicles.
otherwise, for that, I assume it's a fairly rare collection of people 14-year-olds who have RMV records. Otherwise, it's criminal justice, juvenile adjudication, that's the kind of data, right? So the most likely purpose of doing a records check is to sort of see if this person has some kind of criminal justice intersection involvement. Would that be right?
Or is there a record available to me that allows me to confirm the information that I've received? And that serves the limited purpose of affecting the citation. And that here, officers, if we step into what we know about who they encountered in terms of the juvenile and how he appeared, the court does have before it the booking sheet with the biometric information and the photograph, and reviewing de novo can conclude that it was objectively reasonable for the officer to believe he had probable cause to issue certainly the seatbelt citation, because there's no dispute that the juvenile wasn't wearing one, and the question was whether it could be lawfully issued to the juvenile or the driver, which does not change the officer's lawful position of learning the information in the first place.
So do you think it's appropriate for us, looking at the documentary evidence, to determine that the officer could reasonably believe the juvenile was 16 or over?
Yes, or over 12, because the driver then could still be cited for, the officer could still learn and verify the identity and age of the passenger for purposes of issuing a citation to the driver. So it's just a question of where the citation is going, because the seatbelt violation applies to a child who is 12 to 15, who would be cited for the driver, or 16 or over, who themselves would be cited. So yes, I think the court could, in its de novo review, find that objectively reasonable for the officer to have, at that time that he sought the identification of the juvenile, have probable cause for purposes of issuing a seatbelt citation.
So why wasn't the burden on the Commonwealth to establish this at the motion to suppress level? And if that required evidence beyond the police report, then why wasn't it up to the Commonwealth not to stipulate, but to bring in more evidence? That was a two-part question, I'm sorry.
Thank you. In terms of the Commonwealth's burden at the motion to suppress, the burden fell on the Commonwealth to establish the justification for the stop, which wasn't in dispute, and the parties agreed that the factual basis for the judge to decide the legal question was resolved by way of the police report and the materials that were appended to that, including the booking sheet. Had there been testimony, would we still have this question about what the officer subjectively believed? No, perhaps we wouldn't, but the question would remain whether it was objectively reasonable for him to believe he had probable cause at that time to issue the seatbelt citation, and he did. So I don't think...
So you don't agree with the juvenile's counsel that the photograph does not give rise to a reasonable belief that the juvenile was 16 or over?
I don't believe that it renders fundamentally unreasonable the belief that the juvenile could be cited for violation by way of not wearing a seatbelt. It's nothing about the juvenile as depicted or the biometric information or the other facts presented by way of the police report renders the officer's actions patently unreasonable in this case. That would be my position. It was objectively reasonable. And
you're saying that the officer could verify whether the juvenile is 12 or over? Because, or has a legitimate basis for doing that, because if the person is less than 12 years old, not even the driver can be cited?
Not under this provision. So, if I could envision maybe an extreme scenario where possibly it was patently obvious that the age of the child was such that no one could be cited or what have you. But that's simply not what was present here. Turning to the sentencing order, the judge's determination that the judiciary lacks discretion to shorten the term of commitment to DYS to shorter than the age of 21, that determination was correct. The subsection C of the youthful offender sentencing statute, it's not ambiguous, and we won't turn to the rule of lenity to create or resolve an ambiguity where there is none. The provision provides that commitment to DYS will last until the juvenile reaches age 21. And by that very phrase, it contemplates the arrival of the juvenile's 21st birthday as the termination date and not a date sooner. It's also in comport with the remainder of the juvenile statutory sentencing scheme, where it's regularly treated as a fixed period, in that discretion to curtail it, to terminate it early, to discharge a juvenile is conferred to DYS and not to the judiciary. And Terrell really recognized the distinct grants of authority that the legislature made to the judiciary versus DYS.
Terrell is about confinement, and the juvenile court judge there tried to give the juveniles credit for time served, in essence, against confinement in a DYS facility. But it's not about commitment. So does Terrell directly govern?
I believe it does, by analogy, where though it spoke to the duty of treatment and whether that includes confinement and for how long, it referred expressly to the grant of authority to DYS under Chapter 120, Section 6, which cited those provisions, including treatment, whether it includes confinement and for how long.
Right,
It
but-
likewise, includes that Section 6, includes DYS's grant of authority to determine when discharge will take place. And so, by way of that analogy, Terrell recognized the legislature conferred duties of treatment, including whether that in turn includes confinement, granted that to DYS. Terrell recognized that. The very next subdivision of Section 6 speaks to discharge. So it's readily observable that the legislature granted that same duty that it recognized in Terrell and incorporated termination of the commitment and discharge to the community.
Why couldn't the judge have used A and said, I'm going to give you a sentence provided by law under A, and a sentence here that's provided by law is, 2 years, which of course would be way less than 21, and commit someone to DYS under A for 2 years?
Well, in that circumstance, by the way
Does A have to be to a sheriff-controlled youth facility?
I believe is in terms of the sentence the juvenile would receive as an adult, we're talking about incarceration and the term of incarceration commensurate under the law. That's considered still the most severe sentencing option available to the judge in this case. By utilizing subsection C and imposing a commitment to age 21, conferring the juvenile to DYS custody, that's not a commitment to incarceration. That's a commitment to the Department of Youth Services to structure treatment, decide whether it will include any confinement, where and under what terms, regularly reviewed to ensure it's still appropriate for the juvenile, and could include placement at home or elsewhere in the
I think I was being
community.
unclear. So if a judge gives an A sentence and decides to commit someone under an A sentence, where do they get committed to?
I believe it's a lot. The instruction is there. I think Your Honor began to address it. It's under the sheriff's. I believe there's a provision providing that the DYS commissioner commits it perhaps
The paragraph right after
to the
C.
sheriff's care.
Youth offender who's sentenced is provided by law either to a state prison or to a house of correction, but who hasn't yet reached 18 shall be held in a youthful offender unit separate from the general population of adult prisoners, et cetera. Is that what you're referring to?
It is, and I think that.
So that's an A sentence.
And that's why it's the most severe, because it most closely emulates an adult criminal punishment, which is incarceration in the house of correction or a prison, unlike the least severe option under C, which effectuates the legislature's intent of treating the juvenile as least like a criminal as possible and as much like a youth in need of rehabilitation, vesting DYS with the authority to conduct that kind of treatment, rehabilitation, and regular evaluation of what's best for this child in their continued engagement in the community.
You're out of time, but I did want to ask you very briefly to address the Article 30 argument, separation of powers by the juvenile, that simply by, if your interpretation holds, then the Commonwealth simply by indicting the juvenile can exercise the inherent power of the court to sentence defendants by mandating that he get at least commitment to DYS till 21.
I don't believe it's a separation of powers because the moment the juvenile's committed to DYS, the executive agency is in charge of discharging their continued engagement or performance under DYS custody. So that is for that department to...
DYS is another executive branch agency. I guess, I don't think he's meaning to call into question DYS's discretion, but I think what he's saying is that the district attorney, by choosing whether to proceed by complaint or indictment, can ratchet up the potential penalties or potential sanctions, let's say.
But if we're talking about what authority the judiciary has, I guess I'm not understanding the argument in terms of whether the district attorney's office chooses to proceed by way of complaint or indictment as a youthful offender. The prescribed sentencing leaves discretion on the side of the judiciary in terms of whether to suspend commitment should the Commonwealth proceed by way of youthful offender indictment. And it leaves discretion for the executive division with Department of Youth Services in the care and rehabilitation of the child. So if there's any party to be potentially aggrieved by the distribution of power, it strikes me that it would be a complaint by the judiciary that the sentencing effectively removes the juvenile from their control unless they retain jurisdiction over the juvenile by way of probation in a form of a suspended sentence. So that's why I'm struggling to address the argument as raised, and I appreciate the time from the court.
All right.
Well, thank you both. I learned a lot
Yep.
in this argument.
Thank you. Want to do one more? One more? Okay, we're going to do one more case before our morning break, and that is number 23P1414, Fulvio Gentili versus Town of Sturbridge.
May it please the
Gentili,
court.
wherever you're ready.
May it please the court. I am Fulvio Joseph Gentili. I am the pro se plaintiff and appellant in this case. I was admitted to the Massachusetts Bar in 1973, and I retired in 2017. My BBO number is 189060. In May of 2018, we filed a Fifth Amendment taking claim in the Superior Court pursuant to the Williamson County state litigation requirement issued by the U.S. Supreme Court in 1985. At that time, in 2018, there was no Massachusetts case that the town's prescriptive easement was a taking, and there was no Massachusetts case that the prescriptive easement was not a taking. The Superior Court ruled that my claim in the present action is based upon the same fact as complained of in the first Superior Court case and could have been brought at that time. The Superior Court cited, in its ruling, cited Section 25, Restatement Second of Judgments, Comment K, in Massachusetts Rule of Civil Procedure 8A, that relief in the alternative may be demanded and was available to us in the first Superior Court case in 2018. The Superior Court in this proceeding did not mention the concluding part of Comment K of the Restatement Second at page 222 that states, quote, if he fails to maintain in one action because the foundational proposition is held not to exist, he may maintain the second action, end of quote. The Superior Court in this case did not use the case law existing in May of 2018 in making its ruling. In order to have availed ourselves of demanding relief for no-taking damages in the first Superior Court case under Chapter 84, Section 10, the element that the prescriptive easement is not a taking under Massachusetts law was required and did not exist at that time. In contrast, Precedent existed in May of 2018 that the town's intrusion was a Fifth Amendment taking pursuant to United States versus Dickinson case cited in our brief. Quote, property is taken in the constitutional sense when a servitude has been acquired either by agreement or in course of time, end of quote. There's also the Massachusetts cases such as Cayen versus City of Chicopee, which is also cited in our brief, that, quote, interference with the use and enjoyment of private property constitutes a taking in the constitutional sense, end of quote. SCOTUS's Fifth Amendment taking definition included a servitude acquired in course of time, as stated in U.S. versus Dickinson. A servitude pursuant to Black's Law Dictionary, second edition, is a charge or burden resting upon the estate of one estate for the benefit or advantage of another. End of quote. In order to plead alternatively in the 2018 case, ethical violations and sham pleading would have occurred in filing a complaint demanding alternative relief for a taking and for no taking.
I don't understand that. I don't know why you couldn't say, I think this is a taking, but if it's not a taking, I get relief under this other theory. Why is that a sham?
Because the question of no taking is a question of law, not a question of fact. And a trial judge had no ability to make that determination. Pursuant to Chapter 211, Section 5, it's only the Supreme Judicial Court can make that determination.
Why can't a trial judge make a ruling of law? That's what judges do. That's what we do.
The trial court in that situation would be set up for a demonstration. The PE, the easement, the fact is what the intrusion was a prescriptive easement. That's a fact. That's not a jury issue. The question would become, is the intrusion, is the prescriptive easement as declared by the land court a taking or not a taking? There's no way to answer it at the trial level. If you went to a jury...
I don't understand that. The judge, you present your legal arguments, the judge makes a legal decision. If you don't like his legal decision, you appeal it, but the judge makes the legal decision.
If the case went to the jury, how would the judge... If the case went to the jury on those two claims in 2018, how would the judge instruct the jury? If you find the taking, you will award constitutional compensation at the value, or if you do not find the taking...
Why wouldn't the judge have decided what the law required and instructed the jury consistent with what the judge decided the law required?
Because, in fact, that was a determination. We could not make that claim. If we did, in our pleading, we would have violated ethical obligations. There would have been sham pleading because we knew.
This is my question, though. Why is it a sham pleading to say, we think this is a taking, that's our count one, it's a taking, give us an award. Count two, in the alternative, if it's not a taking, we have a claim for special damages, give us that.
Because pleading a no taking in the second count under 230 on Section 87 it becomes a non-issue. We have said on one claim it's a taking, and then on the next claim it's not a taking. It's inconsistent. It's inconsistent. It also doesn't rise to a level that you can make a determination because we have this case law that we have cited. We have been foreclosed on the issue as to whether they're taking or no taking. It's inconsistent. And that is, it also requires that we would plead, knowing that there is no case law, that it was not a taking. When the Supreme Court case, the SCOTUS case, indicated it was a taking, and when the Cayen case versus Town of Chicopee also had indicated it was a taking. The Supreme Court, the SJC on its own, case of first impression, decided a prescriptive easement is not a taking. And the example, I think the better example would be, work is done. We're all familiar with contract law from law school. work is done, issued for the jury, was it done under a contract, or was there no contract? If there's no contract, the judge says you may award quantum merit damages. If there is a contract, you award benefit of the bargain damages. That is clearly an alternative, an alternative relief available under the statute, under alternative pleading. What we had before, and what the judge in this case has indicated, that it's not possible, that it would be possible. But in fact, under the Mancuso versus Clincher standard do the facts form a convenient trial unit? Do the facts form a convenient trial unit? It's determinative that those facts do not establish a convenient trial unit. There is no fact to determine. The fact is the intrusion has been held by the land court to be a prescriptive easement. There's no issue for a jury. There is no alternative relief available to the jury. The issue is, was there alternative relief available to us? And there wasn't, because there was no finding, no case law establishing it wasn't a taking, was not a taking. Going back to the comment K of the restatement, that if the foundational proposition that we advocated in the first case, it is a taking, is found not to exist, and it was found not to exist by the Supreme Court, then we maintain the second action. And it shows it's not the same facts, and in order to make the facts conform to what the Supreme Court, and to what the Superior Court in this case set forth, we would have to engage in ethical violations, making claims that don't exist. We would have to say the law in Massachusetts is that it's not a taking. It didn't exist at that time. We would be making an ethical violation.
Couldn't you say, we think the law as it is a taking, but in the alternative it isn't, we recover under this ground?
We don't have any statute. We do have no authority to say it's not a taking. But we have contrary authority under the SCOTUS decision that it was a taking, because
It seems like this argument requires us to find the SJC was wrong.
What?
If you're saying that there's no way under the case law to find that this wasn't a taking, then isn't the SJC decision wrong?
The SJC is final decision. It was not appealed to the Supreme Court of the United States. It's the law of Massachusetts. And we found ourselves in this position because of the state litigation requirement that SCOTUS abolished in 2019. And any federal case that we filed couldn't overturn what SJC did because of the Rooker-Feldman doctrine, which is cited in our briefs, and the case cited in the reply brief, Ephraim versus McKay in the Seventh Circuit of 2022.
If I understand your argument based on Nick correctly, it's that the Nick case from the Supreme Court recognized that previously plaintiffs were in a dilemma, that if they went through the state compensation procedure and then they lost, they might be frozen out of federal court by issue preclusion or claim preclusion. So assuming, for purposes of argument, that Nick relieves you of that burden and frees you up to go to federal court, the issue here is whether you could come back to state court and assert a Fifth Amendment taking claim for the second time. You tried it once, and the Superior Court rejected it, and the SJC affirmed that, and now you sued the town again in Superior Court, and the judge said that's precluded, claim preclusion. How does Nick help you in that situation?
Because if Nick had been decided in 2017, we wouldn't have had to file in Superior Court. We would have gone to the Federal District Court, Fifth Amendment taking claim under U.S. versus Dickinson, and it would have been adjudicated. If it's found to be a taking claim, finished. If it's not found to be if it's found not to be a taking, then we've set forth in our brief There's no supplemental jurisdiction at that point.
But
Federal
you-
law specifically.
So you went to state court because you had to exhaust the state compensation?
right.
All right, but did you have to assert a Fifth Amendment claim in state court?
Yes. Yes.
Why?
And that is the Williamson County case. You had to go to state court and pursue the Fifth Amendment claim in the state court first. And that was overturned by Nick in 2019. And that would have allowed us to go forward. And if we were found to be, if it was found not to be a taking, it wouldn't preclude coming into state court because the federal court wouldn't have any supplemental jurisdiction, as we set forth in our brief. And under U.S. Code 28-1367C, Section C, it mandates that supplemental jurisdiction wouldn't exist. So we would be back here. So Nick is an exception. And another exception to res judicata, the SJC was critical of our failure to do anything in before 2015. And rhetorically, how were we supposed to do anything to stop a prescriptive easement or to make any claim for damages if the town failed to disclose what the truth was?
Because it was open, notorious, and continuous.
Excuse me?
The land court found, and you didn't appeal, that what was happening was open, notorious, and continuous. So it was open and notorious, you should have seen it, and you should have filed a lawsuit before the
Well,
statute of
that would
limitations
require
ran.
that we go during storms and sit there. And we also had, but more importantly, we had a determination in 1999 that there was no water on the property. So for our purposes, the 20-year period didn't start until 1999 and didn't end until 2017.
If you thought the land court was wrong to find, if you thought the land court was wrong to say that this was open and notorious, why didn't you appeal?
Because we took the alternative of filing for compensation.
And aren't you stuck with that
compensation.
land court opinion now?
We did not have the information that the town presented to the land court that we had never seen before. And that goes to the fundamental fairness argument that we've cited in our reply brief under Devine versus the town of Nantucket. They withheld all this information until the prescriptive easement period expired, knowing a lot more than
Why
ever
is
disclosed.
it unfair when the trustees, of which you were one of them, ignore open and notorious conditions for 20 years? Shouldn't the beneficiaries be able to sue the trustees for that?
The open and notorious conditions, vacant land on a highway. You have to go there and sit and watch the land watch water come in during rainstorms, snowstorms. My father was dying at that point in time, and I was in law school and going on to try and practice law. And the point was, it wasn't a transited area like going on to the beach, go by somebody's house. It's a vacant land in the middle of Route 20, near Route 20, where cars go back and forth. And we had a determination in 1999 that there was no water on the property. Okay. Why would we have anything other than that in our mind? That was a 20-year period.
Mr. Gentile, we're going to have to leave it there. Your time is up, but
thank you, Your Honor.
We'll take the rest of it on your brief. Thank you very much for your argument. Mr. Trapani.
Good afternoon, or good morning. May it please the court, Jeff Trapani on behalf of the town of Sturbridge. The plaintiff's latest iteration of this claim for damages seeks to fashion a claim under Chapter 8410, which goes towards the maintenance and protection of roads, seeking damages for lost sales from 2009, 2013, and 2015. And after the prescriptive easements had vested, and because of the prescriptive easements were there. He makes a very distinct claim in his brief. It's the clearest iteration of what he's seeking. He's saying, these prescriptive easements caused my harm, and therefore I'm entitled to damages under 8410, and that subsumes Chapter 79, Section 12 into it. I know that you've read the briefs, but if I could briefly just say, because this isn't just something that happened out of nowhere, this area in Sturbridge, there's a hill called Fisk Hill. And the land court did a fantastic job of outlining this, but there's a hill that has a stream that runs down, a ravine that then ends up at Hall Road, there's a culvert that has been there, some culvert that has been there since the 30s, almost 100 years ago. The next, if you go under Hall Road, then you end up into Mr. Gentili's, well, now Mr. Gentili's property, which then goes, if you keep going down the hill, it goes towards Route 20 or Route 20. There's another culvert maintained by the state, and then that goes into a swampy area and a brook. And so that has existed for as long as time, well, as long as anyone here can think back. So there's been culverts in existence, but the land court focused on the 1987 culvert, which was called the new culvert, where road construction was done because the state was doing construction to Route 20, and so they put in a new culvert that was 7.5 feet longer, extended 7.5 feet into Mr. Gentili's property, and then also there was still the discharge. The land court found that there was a prescriptive easement for the new culvert from 1987 when it was installed to 2007 under 187 Section 2, the prescriptive easement statute, and then there was a prescriptive easement for the discharge of this water. So we have claims filed in the land court which determined that this was a prescriptive easement. Then we have two claims in the Superior Court, and I think the dates are important here. So we have the May 2018 Superior Court action, the first one. That's disposed of in May of 2019, around about a year later, and the Supreme Judicial Court then issues its decision in February 2020 saying they're affirming that there is no taking. Then there's the first federal action filed before Judge Hillman in Worcester, in the Worcester Division of the federal court on June 1st, 2020, and that's disposed of in August of 2021, citing res judicata and also the Rooker-Feldman doctrine. Then there's the second federal action, which is in my supplemental brief. And in that action, Mr. Gentili sought to sue the Commonwealth, specifically naming the Supreme Judicial Court. And that is disposed of in July of 2022. The relevance to that, the reason why I put that in our supplemental brief is because I guess seeing writing on the wall, Mr. Gentili moves to, or offers to move to amend to substitute the SJC with the town, and is seeking the exact same damages we have here. So even if we didn't have the prior claims, we have him trying to substitute and seek the damages here. As far as our res judicata argument, with respect to the claim preclusion, we obviously have privity. I don't think that's been contested in any way. Mr. Gentili has been standing in front of courts for these claims since the beginning. We have final judgments from courts, ones that have been appealed and ones that have not. And as far as the claims, I would just note that while the causes of action while he may be seeking different forms of liability, the causes of action still arise out of the same transaction acts, which are the ones that I just described. And the ones that are frankly described in his complaint very well. His complaint more or less mirrors the land court findings. And I would also note that there's no allegations outside of those, of the finding of a prescriptive easement and the use of the prescriptive easement. In other words, he hasn't alleged any sort of overburdening of the easement or anything like that. It's just that the prescriptive easement exists and that the use of the prescriptive easement is causing him harm. And so therefore, with respect to whether he could have or should have brought these claims, I think you've discussed, it's been discussed enough. Rule 8 would have allowed him to have alternative pleading. I think that could have been dealt with in discovery and motion practice, or a jury could have been instructed properly as to whether there was a taking or there was something less than a taking.
May I just back up a second and ask you, you said that the new culvert extended 7.5 feet onto Mr. Gentili's land.
Yes.
That sounds less like an easement and more like maybe a physical occupation.
Well, yes, so there was
I'm wondering whether why the town didn't take the land or take an easement, if that's the way you want to look at it, at that time.
So they extended it 7.5 feet. It's in the land court decision. It was considered by the land court, and the land court found that the extension of that was a prescriptive easement. Now, again, I guess I would start with...
Does the record indicate whether that culvert is visible?
My understanding of it from the record is that it was visible. It extended onto the land out from the road, so that it would be visible to anyone during rain events. The water discharging from the end of it would be visible, and not just rain events, because at some point I think the land court even notes that it becomes an intermittent stream, or was an intermittent stream. But I guess to that point, an 8410 claim under Malinowski and then Triangle Center, you have to, and this would have been the law when all of this was happening, to take that, you would have to do it under the procedure under Chapter 79.1. It's not you can't get damages for taking in pay. And so when Mr. Gentili or the trust was trying to decipher what claims they wanted to bring back then, they would have known that, well, I can bring a nuisance claim, I can bring a trespass claim, I can assert a takings claim, but Malinowski and Triangle Center would also say that without an order of taking, I might not have a taking here. The fact of the matter is, and I don't want to mix too many of the arguments, but by the time they did do something, which was in 2015, when they filed with the land court, the inverse condemnation claim was untimely because the prescriptive easement had vested by 2007. And while they battled that in land court, the vesting still had a date of 2007, and so it would naturally be too late to bring that claim. And prescriptive easements for towns had been recognized prior to that. I think both of us cited the same cases. There's the Puffer case, I believe, and the Danvers case, where they found prescriptive easements under 187-2. And then I guess I would just like to address the inference of fraud, that he didn't know these things were happening. That's squarely dealt with in the land court. They deal with what he knew, when he knew it, what he didn't do, and what didn't happen. So I don't think that is a live issue or should change anything. With respect to issue preclusion, which was not relied upon, but I think is important here, because of the claim he's bringing, he's looking for, and when I say not relied upon by the judge in her decision, but was argued in the motion to dismiss. What happened here is, or what he's asserting is, that he's entitled to damages from lost sales in 2009, 2013, and 2015. But the issue of whether he could get those sort of damages had already been decided. So almost all of his complaints allude to these, either 1, 2, or 3 of these lost sales. So that was clearly in play in the other claims. The other thing is that he had argued prior that he was entitled to special and peculiar damages, which are damages when the taking doesn't occur. So he's asserting that he's entitled to something other than damages for something other than taking in his prior claims. But the issue of whether he could get damages for the use of the culvert and the discharge of water, the 2 prescriptive easements, has been resolved by the land court. The land court said that is a proper prescriptive easement. It's being used appropriately, reasonably. There's no allegations of overburdening, and so whether he can now get any damages for that has been precluded by the issue of the prescriptive easements being found valid. And so that kind of lends itself to also saying that he doesn't have a claim. He doesn't have a claim under 8410 because 8410 is more or less a takings statute. There's been no takings here. Malinowski says that. And the other non-taking sort of conduct that 8410 discusses is something that's not triggered here. It's very temporary use to do sort of surveys, park cars, things like that, it seems to be. And Malinowski and Triangle Center talk about that. So 8410 really does not encompass this sort of claim. And I would also say that 83.4, because of the number of claims that have been brought, I would say here that Chapter 83.4, which is discussed in Triangle Center more, which is for drainage of public ways, also wouldn't apply because Malinowski and Triangle Center both say that 83.4 and 84.10 require conformity with 79.1. And so therefore, he would not have a claim under those 2 statutes.
How it may not be presented here, but how does one bring an inverse condemnation type of claim?
Well, he would have to assert, I would say that a taking hadn't occurred, and I think that's what was argued to the SJC. There could be a nuisance claim there could also be a trespass claim. And I can't remember, Your Honor, if it was Malinowski or Triangle Center, but those were alternative claims, I believe, that were brought in those. And there's also a case with Judge Simons, the case McSorley out of Berkshire County, where they brought other avenues
I
of claims.
suppose if either of those actions had been brought, the town would have either had to have undone the improvements or do a taking?
They would have had to make some decisions, because they could either be liable
Are
for...
those the options?
Yes, I mean, those are the options. If they were trespassing, they're trespassing. And so...
You put a culvert on his property, so
Right.
it's a trespass.
And there was discharge of water. So arguably, you would bring a nuisance claim or a trespass claim, and just like any trespasser, they can be ejected. Or the alternative to not being ejected is the remedies that a town or city or the Commonwealth have been afforded. Finally, I should probably just mention, or the two things I should mention, the exhaustion requirement. Your Honor, you picked up on it. Mr. Gentili did decide to bring Fifth Amendment claims before the state court. I'm not sure whether he could have brought a diversity claim because of where he lives, but regardless, he brought a Fifth Amendment claim. He had that litigated in the state courts, and just like the San Remo decision, which we cite to, where there was a Fifth Amendment claim, I think they were changing residential units to tourist units, and they had to pay a fee, and they found that to be a taking, and there was very convoluted federal and state actions going on. But the state action handled the federal action. The California Supreme Court made a ruling on the Fifth Amendment takings, and the federal court said, you don't get to do it again here, that law's good. Your remedy would be to appeal here the SJC, the Supreme Judicial Court's decision, if he disagreed with it, applying the Texaco case to the Supreme Court, not file these other actions as he's done here. And then finally, with respect to statute of limitations, there are ways where people challenge inequity, whether there's a taking and whether there's some sort of assessment of damages, because sometimes they can be provided damages under Section 6 and 7, or they can be offered, and they might disagree with that. However, there are strict compliance rules to when you then have the taking or something found not to be a taking or to be a taking, when you can file your subsequent action. Here, those statutes don't come into play because of the prescriptive easement, but even if they did, he was way beyond the times for doing that. And I would rest on if there's no questions, I'd rest on my brief.
All right. Thank you very much. Thanks to both of you for your arguments. We'll take our morning recess now. We'll be back in 15 minutes.
Take care.
Traveling back.
right, we are back in session for our last two cases. I want to welcome summer interns who are working in state government for our final two arguments. The first of them is 23P 1016, Karen Murphy versus Patricia Levitas. I'm not sure I'm pronouncing that correctly, but perhaps you'll correct me. Mr. Jafarian.
Thank you, Your Honor. If it may please the court, my name is Thomas Jafarian, and I represent Daniel Levitas and Patricia Levitas. Like the case before us, this was an action with regard to easements, but more specifically, private nuisance. That was the remedy involved here. So, presented in our brief, Your Honors, is the notion, is a suggestion that this was not a private easement, that the elements of a private easement were not satisfied. If we look at case law in this matter, Alicia versus New Bedford, I'm sorry, New Initial case, this matter has to involve two parcels of land. One parcel of land has to be where the offensive action has taken place, and the other parcel of land has to be where the offensive action has taken effect, has affected.
So you've got the parcel of land that your clients own, and you've got the other parcel that the Murphys own with an easement appurtenant to it.
Correct, Your Honor.
That's part of that property, isn't it? That easement?
No, so what I would suggest to the court is that
it's in their deed.
It's in their deed, but where the offensive action did take place on the defendant's property, yes. However, that offensive action did not affect the Murphy's property in the classic easement scenario. Classic easement scenario, Your Honors, is we have a sight or a smell.
Maybe not classic, but part of the enjoyment of 52 Loring Avenue is the ability to go to the beach and sit in the beach, and your clients interfered with their enjoyment of 52 Loring, which includes that right.
There was an interference, yes, Your Honor. However, that interference, what it interfered with was that beach area. That beach area is the same land as that is owned by the defendants. It is one and the same parcel of land. So I would suggest to you there are not two separate pieces of land here. And presented on day one of the trial, there was a motion to dismiss to that effect. The trial judge cited the Connery case, which has nothing to do per se with two separate pieces of land per se.
It says that holders of easement have been permitted to recover in nuisance actions, right?
Correct.
So isn't that the issue here, right? The Murphys are holders of the easement, and
yes, owners of easements and tenants have been shown to prevail in cases of private nuisance. However, I would suggest to the court that two things. Number one, there's no definitive case law with respect to an owner of an easement prevailing in a private nuisance in a scenario like this. There is some case law with respect to tenants of land.
right?
However,
But that case law involves, the tenant is not allowed to sue the owner for a nuisance that's occurring on the property, and that's why they say, well, we have two parcels of land. But this is more of a classic example of the holder of an easement bringing a nuisance claim against the servient estate that's interfering with their enjoyment of the easement. You're saying, do you have any case that says that's not a basis for a private nuisance claim?
no, there's no case law with respect that supports that an easement holder can sue in that fashion. It was just, the Connery matter states that, that's what the trial judge used in order to combat the motion to dismiss.
Yeah.
In his words, when he presented the Connery case, as you suggested, Your Honor, yes, owners of easements can sue as well as tenants, okay? However, there's case law where tenants have prevailed in a lawsuit, but there's also case law where tenants have not.
Yeah. So the tenants in was it the Doe versus New Bedford Housing Authority?
Yes, Doe versus.
So they were in privity with the landlord there. I mean, they probably had other remedies.
They may have other remedies in Doe, yes, Your Honor. However, Doe.
Under state law governing landlord-tenant relationships, as well as a lease or tenancy agreement.
Doe's property interest or property right is born out of the owner's, or in that instance, the landlord's land. Same applies here. You can draw the same conclusion, the same parallel.
Well,
Murphy's right is born out of the Levitas' ownership of the property. It's one and the same piece of property. That piece of property is the property that initiated and caused the substantial interference, and it's also the same property where the substantial interference has taken place. I'll give you...
So let me ask you, if they can't sue in nuisance, what is their remedy?
So if they can't sue in nuisance, Your Honor, injunction, special damages, but I
Injunction
just
for
don't...
what?
I'm sorry?
Injunction for what?
Injunctive relief for the interference. It would just be the same as if the utility company came to the land and they were precluded from using the easement that also the utility company has on that same parcel of land. They could seek injunctive relief.
But they can never get damages?
No, they could get damages. I'm not stating that, but
What theory?
I'm sorry?
Under what theory?
There could be special damages under injunctive relief. But my argument here today,
Under
Your
a
Honor,
private nuisance theory?
well, not under the private nuisance theory.
Okay, well, what other theory? I mean, you have to have a
Well,
legal theory to support an injunctive claim. I mean, the problem is you can't actually argue that an easement holder has no remedy against a property owner on which
No,
the
and I'm not
easement is
arguing that.
located.
What
Okay,
I'm-
but
what
what
I'm-
is the theory that's allowed if you don't think a private nuisance theory is allowed?
Other than injunctive relief, I don't know what the theory would be, but my being here and presenting it in front of the court is that I don't see how the first two elements of private nuisance are satisfied, because it's the same parcel of land. That's the issue. I'll give you an example. Let's say before us we have three parcels of land, A, B, and C is behind us. If A and B, if there's an easement going down between A and B that's 10 feet wide, let's say, okay, and property owners in C have access to that easement. They walk down the easement. Property A decides to put a bee's nest there. They're harvesting bees to make honey. And those bees interfere with property owner C's ability and enjoyment of that easement, because he's constantly getting stung, his guests are constantly getting stung. The question becomes, does he have a case in private nuisance there? I would submit, yes, he does.
All right, so how about A and B? B has a driveway easement over A, it's the only way to get to B, and the people in A block that driveway, so now you can't enjoy the use of B. Nuisance? Why isn't there a nuisance claim there?
You have A and B, there's a driveway running
Driveway, you block the driveway, now you can't enjoy B. Why isn't that a nuisance?
Well, there are two separate pieces of property there.
Right, so just like here, we got 52 Loring Avenue and 54 Loring Avenue.
Well, where's the actual objection taking place? On B or on?
I'm saying on A, they blocked the driveway, so now you can't get to B. Why doesn't B have a nuisance claim against A? Now they can't enjoy B anymore.
Well, I'm not looking at it in those terms, Your Honor. I still believe that there's still one parcel of land here that's completely affected, and not the two parcels of land.
Don't both A and B, or don't both the Murphys and the Levituses have property interests in the area where the easement is? The Levituses own the fee. The Murphys have the right to use it.
Yes.
For certain
I don't-
purposes. Okay,
right.
so, and that right is appurtenant to their property.
I don't dispute that, Your Honor. What I'm disputing is that when you're looking at the case law, the affected area is a separate piece of property. If I'm sitting on my front deck and I look across the street at my neighbor and I can see some offensive act, whether it's a sight or sound or smell, he's got chickens, that's two separate pieces of property there. Here, the offensive action took place on the Levitus' property, and it affected the Levitus' property. It affected the beach area. That is one separate piece of property. That's very similar to Doe, where in both instances, whether it's the Murphys or Doe, their interest is born out of the ownership of the defendant who owns the property. So looking at the elements of a private nuisance, those first two elements, I don't see how they're satisfied. Similar to, and during the jury instructions, the the judge actually did say we have two parcels of land, one owned by one individual, one owned by the other neighbor. However, there was no instruction with respect to is one property conducting an offensive action that affects the other property itself.
Right, but you didn't make an objection to that aspect of the jury instruction. You did not object to that jury instruction. On that ground.
Right, I did not to that jury instruction.
really
But
reviewable
what
by
I'm,
us.
what I'm stating is that to simply state that there's two pieces of property and two owners is not the elements of a private nuisance. The elements are, again, an offensive action on one that is affecting the property, the land, the actual land of the other. So in this instance, the offensive action that did take place did not adversely affect the land of the plaintiffs.
But it affects the easement right, the easement interest. And so I just don't, if the easement interest isn't protected by the private nuisance claim, I guess that's your argument, but that just seems contrary to common sense. How can you protect your interest in an easement if you can't take legal action against someone who puts yellow tape or poison ivy or whatever in the way that
Right.
you're allowed to use it, right? There has to be some remedy, don't you think?
Yes, Your Honor, there has to be some remedy. However, because the case law, and that's been introduced, whether it's by my brother or a case law in the past, it always shows that there's two separate pieces of land, that the offensive action has not taken place on the same land as the defendant.
Does the case law use the word land, or does it use the word property?
Well, Your Honor, that's interesting that you ask, because it goes back and forth. If you look at some of the model rules, they use the word land. Obviously, property land is a form of property, but there's no clear-cut definition. So when you look at the case law, some states the land has to be affected, and in this instance, that's why I state that the beach area that's in question here, or the easement area, that is what's affected.
So you rely on Asiala versus Fitchburg. That's your first case for the proposition about two pieces of whether land or property?
Yes.
So, and Asiala says, when a property owner creates a condition that causes substantial unreasonable interference with the use and enjoyment of the property of another, is not the easement the property of the Murphys? They own it. It's in their deed.
They own it. It's in their deed, but it doesn't affect the land. It doesn't affect the actual.
You have a case that says there must be an effect on land. To bring a nuisance claim, there must be an interference with your use and enjoyment of land that you own in fee.
No, Your Honor, there's no case on that, nor is there any case with respect to an easement holder being able to.
Asiala seems to say property of another, and easement is property, so what's the problem?
Easement is a property. However, it doesn't affect the actual property. It doesn't affect the land there, Your Honor.
So if the plaintiffs have a remedy for what your clients did in special damages, why would those damages be different than the damages that were set here?
They may not be different, Your Honor.
What's the harm? If the judge gave the wrong label to the jury but got them to decide the right thing?
Well, the harm here is that the jury was able to go forward with a nuisance matter where I don't see this rising to a private nuisance.
But if the judge had said, okay, figure out the special damages for interference with the easement, and they came back, that's fine. So why does it matter that the jury was told nuisance instead of special damages?
Well, because it's when somebody is given elements of a tort and those elements aren't satisfied, I don't think that's the direction.
What element of special damages for this easement violation wasn't satisfied or wasn't told to the jury?
I'm not arguing that, Your Honor. I'm arguing the private nuisance per se.
Well, I understand, but you say there's a remedy. It's in special damages, and so I'm trying to understand if the judge had correctly instructed on special damages, what would have been different? Because if the answer is nothing's different, then there's no prejudice to your clients. So what's different with a special damages action?
Well, the difference with respect to private nuisance and special damages is that there's an interference, certainly, yes, but if you read the elements of a private nuisance has to be unreasonable. It has to be, in some cases, reckless. And those instructions, a jury would have to look at just to see the exact definition and elements of a private nuisance, which is far greater. If you look at...
And special damages doesn't have to be reckless? Is that what the difference is?
It's special damages, no, I just think a private nuisance is far greater. I think special damages the definition is far more benign and a lower bar to achieve than...
So the plaintiffs actually suffered a higher bar in proving their case this way than they should have?
I think proving a private nuisance is a higher bar, yes, Your Honor.
Well, if the plaintiffs proved this higher bar, then isn't all the error in the favor of your clients? Because the instruction should have been it's much easier to get damages for the special damages.
It's a higher bar, but in the jury instructions, it was stated that there's already a nuisance. And the jury instructions said, did the plaintiffs have the ability to reasonably use their property? Not did the defendants unreasonably use their property. Even so, the jury instructions were off in that respect. Sure, plaintiffs were able to reasonably use their property, but what the higher bar is of a private nuisance is...
You're going to need to wrap up, so finish the sentence.
Certainly, Your Honor. So the higher bar is that did the defendants unreasonably use their property and cause a substantial offensive action?
Thank you.
Thank you, Your Honor.
Hear from Mr. Ross for the plaintiffs.
Good afternoon, Your Honors. John Ross for the appellees. I was the trial counsel in Barnstable Superior Court, and by way of background, the Murphys purchased this property in 2016 in December, and they purchased it from a developer named Paul Butler. Paul Butler had bought the Murphys' home and remodeled it, and the Murphys' home sat on almost 2 acres of land that abuts Kelly's Pond. The other part of the land was undeveloped. Mr. Butler cut this lot out and marketed the house as having an 8-foot right-of-way to Kelly's Pond on the left side of the Murphys' property. Mr. Butler said that that enhanced the value of the property as you go down this path and enjoy a saltwater pond with paddle boards and kayaks and go swimming. It was one of the reasons the Murphys purchased the property. Subsequent to that, Mr. Butler decided to develop the property. The Murphys had an express easement to go to that pond on that 8-foot strip since December of 2016. They enjoyed it without any problems, difficulties. Initially, it didn't matter because Mr. Butler said you could just walk out the back of the property. There was paths created over time.
Mr. Ross, I'm just going to stop you and say we know the facts.
All right. Okay.
It would be most helpful if you got to the arguments.
All right. I'm saying the Connery case is right on point. In the Connery case, it actually cites Keenan, Prosser on tort. It expressly says that an easement gives you rights to a nuisance claim, and that's all we're doing here. We brought the claim. If you look at page 34, I had outlined the Connery, and on page 34 is all the particular case law I want you to look at.
Can I just jump ahead? And are you aware of any case that explicitly says that a holder of an easement has, other than Connery, it actually applies the rule that the holder of an easement has a private nuisance claim against a serving estate, where that estate, or the owner of the serving estate that interferes with the easement?
In the Connery case, it was a violation of someone's rights to shellfish, And they just said that as a result of them having just a license. They're saying that's not enough. You have to have something such as an easement.
Okay. So that's your best authority in Massachusetts?
I believe the Texaco case versus Hoyle Machine has some verbiage, and that's an appeals court case.
Okay.
The Connery case is a Supreme Court case.
Let me ask you about the two parcels problem. Looking at the instructions, the model Superior Court instructions, that's in there, and I know the judge here instructed the jury on the two parcels issue. But it looks like from the instructions that it's framed as an issue just to address the specific problem in Doe, where a tenant suing the landlord for the same property. Do you think that there have to be two parcels generally to bring a private nuisance claim, or does it really depend on the particular kind of claim that's
No,
being
in
brought?
the Fitchburg case that the other judges cited, that's two parcels of land, but there was a failed retaining wall, from what I understand, that created the nuisance. It was not an easement. It was some defective retaining wall that affected the private owner's, I think, a multifamily unit. I think that's a completely different set of circumstances than what we have here.
So would it be your position that an easement holder has a private nuisance claim against a servient estate, even if there is no other parcel of land involved?
I would think so, yes.
Okay.
And to argue that we don't have a claim when a series of events took place to impede the Murphys from using this. And it's interesting that the jury was out a short period of time and came back and wanted to give attorney's fees that would tell me and this court that they did not like what was happening on that easement with the appellees. And they came back and awarded $60,000, which would tell you that the behavior that stopped the Murphys from using that easement was behavior the juries did not think was appropriate. We would also suggest that some of these arguments being made were not preserved at the trial court, especially the verdict slip, which he agreed to, and he never objected to the jury instruction.
There was discussion at the charge conference. There was a request for a different instruction that the judge didn't provide, but there was no objection to the issue that's actually raised and after the charge was given. Is that correct? Okay.
Unless there are further questions, I think we have your argument.
Thank you.
Thank you both. Our final case for the day is 23P556, Perdomo versus Brooks, Chief of Police of Norwood.
Good afternoon, Your Honors. May it please the Court, my name is William Smith. It's my privilege to represent Mr. Perdomo. He's here today to my left and behind. Your Honors, the old phrase, timing is everything, really comes into play here in terms of the first issue, certainly in this, in my brief, which is here what happened was my client's LTC was suspended. So the given reason why it was suspended was that at that time he had an active restraining order against him. I would suggest under federal law, under state law, in fact, I mean, it would disqualify him as long as there's an open order that's open. And of course, Rahimi affirms the constitutionality of that just a couple of weeks ago. But that's not what this is. This is the order was terminated a matter of a couple of days after it was issued. So it was terminated, the sequence, the temporal sequence there, in fact, was my client never even had the opportunity to address it because it was terminated before a...
She didn't recant the allegations, though, did she?
Well, she didn't recant them, but by the same token, first off, I mean, for someone to recant them, they'd be placing themselves at jeopardy, right? They could be prosecuted for perjury if they recanted. But beyond that, here we have more than that here. Because when my client applied in 2019, Your Honor, for his LTC, there's an interoffice memo that was made part of the record in this case from one of the officers, I believe, to the chief of police, where he said that he spoke to her.
Whatever happened in 2019 doesn't bear on whether she did, the chief could believe the allegations in her 2020
Correct,
affidavit.
but I would suggest certainly it does, because then the police said all of a sudden that the older one did matter. So they say that only after, that literally the day after my client appealed this to the district court.
Okay, so the chief testifies to at the district court hearing that when we're notified that a restraining order has issued, it means the person is prohibited by both state and federal law from possessing a firearm. So we immediately suspend. But then we look further into the circumstances behind the restraining order to see if there are other facts that we should know about. The initial letter, which your client received, is automatically generated by the licensing system. But the chief says, because the restraining order is an absolute bar, we suspend, but then we always, as a matter of course, seek the affidavit filed by the plaintiff in support of the order. Does the statute bar that procedure?
Statute does, I would suggest, number one, I mean, part of my argument here, of course, is that this procedure in Chapter 140, Section 131, it violates Bruin. But putting that aside, I mean, the fact of the matter is, to do this, the statute also says, Section 131 says, the reason for the suspension shall be put into
Can I ask you this? Are you challenging the suspension, or are you challenging the denial of reinstatement?
Well, I mean, I get both, I guess. His license is still suspended all these years
how can you
later.
challenge the suspension? The suspension was certainly correct because when he was suspended, there was an active restraining order against him,
For
right?
those couple of days.
Right. So the suspension's fine. It's the denial of reinstatement that's the problem, isn't it?
Correct. But his license remains suspended to this day.
So why, when you suspend someone, why are you stuck when you deny reinstatement with what the universe was at the time of suspension? Why can't you, when you deny reinstatement, issue new reasons that you've derived from new information you've gotten since the suspension?
Well, first, if this was not new information, they testified expressly, the licensing authority testified expressly that they were cognizant of this information at the time my client applied into circa 2019. So this is not new information. They were cognizant of that. They found he was suitable. I mean, they gave him a license. So that is
Right.
an
But
at a
my
minimum
question
an implicit
is,
finding.
my question is, you have briefed this saying, you do a suspension letter, and then a letter explaining the denial of reinstatement can't even be considered. And so I'm asking you why that's true. And maybe that's not your position. That seemed to be what your position was in your brief. So why would that be true?
I'm sorry, Your Honor, I'm just not following the question.
All right, so he gets suspended. The suspension is completely correct because he's got an active restraining order against him. 100% right, that suspension.
And I'm sorry, if I could intervene, I would say, in fact, it really probably should have been labeled as a revocation.
Probably should have been revocation, but if it's revocation, he'd have to apply again. So then he asks to be reinstated. He says, hey, restraining order's gone, reinstate my license. And we get a letter explaining why they're not reinstating and you're saying that letter can't be considered, and I don't understand why.
Because he appealed pursuant to Section 131, Your Honor. He appealed that suspension, and the basis was, well, okay, there was an active order at some time. It lasted, I don't know, roughly 48 hours, and it is no longer extant. So that was what his appeal was. It was based on the fact that
if that is the appeal, if the appeal is solely of his suspension, don't we have to affirm, because that suspension was definitely correct, because at the time he was suspended, he had an active restraining order against him.
I'm sorry, I see. No, but the fact is, then there was this hearing, and after he appeals it, they say, well, here's an additional reason for the suspension.
That was still within the 90 days after he requested reinstatement, wasn't it?
It was with it. I believe so. I mean, I would caution, I don't know off the top of my head how many days it was from the date of the original notice that he appealed. It was timely. It was certainly timely.
So,
but I can't say I know off the top.
And if you apply for a license, and perhaps it's even explicit that if you apply for reinstatement and you don't get an answer after 90 days, then you can go to court under 131F?
Well, I mean, my reading of the statute is the statute requires as a condition precedent that first the licensing authority has to provide written notice. I mean, it's very express on that. So if I'm unclear in terms of applying for reinstatement. The fact of the matter is you have the right to appeal it. You have the right to appeal a suspension, a revocation. I mean, maybe someone's, I've had situations where someone's LTC is actually revoked. And it turns out they were not convicted. There might be some error in the query system or something of that nature. But in any event, that is what happened here. The day after, then this supplemental reason is given. Now, that's one thing, but it isn't just that. The problem is it was information to which the licensing authority was already privy to.
Let me ask you this.
They were.
We got a police chief, and he sees all this concerning stuff about an applicant. And he says, well, it's concerning, but this is a Second Amendment right. This is an important right. So even though it's close to making me think he shouldn't have it, it's not quite enough. I'm going to give him the license.
Right.
And then some new fact comes in that takes it from 49 to 51. Why can't the revocation be based on everything before that was concerning but not quite enough, plus the new stuff? Why do you have to ignore that 49%?
Well, I mean, I would suggest for a couple of reasons, I think all of which I addressed at various points in my brief. One of which is Section 131 says the reason must be stated in the notice, period. I mean, it doesn't provide for such a procedure. And I think that's what counsel below argued, if nothing else, certainly argued that, look, statutorily, it's just, there's no provision for it in the Mass General laws, including Section 131.
There's no provision for considering older information?
Well, it's not a question of considering it. It's a question of then adding this older information, as you term it, Your Honor, adding it to the basis for the suspension.
Okay.
Because
so
Section
let's say you're
131
right.
makes no provision.
Let's say you're right that if not all of the reasons were stated in the original letter, but some of them only in a supplemental letter, and everything had to be in the original letter or else couldn't be considered, then maybe the original suspension gets vacated. What's in the statute prevents the chief the next day from saying, okay, now based on what the original reasons and what I said in my supplemental letter, I'm suspending you again.
No, I understand your question, Your Honor. Had that happened, well, it still is problematic, if nothing else, by putting aside constitutional issues. But in terms of my first argument,
why is it still problematic? Just a sec. Let me finish my question, please. Why is it problematic, and why isn't why wouldn't that just put everyone through a meaningless procedure that can be avoided if the supplemental reasons are considered in the first instance?
Well, because first of all, here, if you look at this under principles of claim preclusion, issue preclusion, here, they were already privy to all of that information. And they found that based on knowing that information, he was suitable. So the fact of the matter is, as I outlined, the case law.
At the time of the initial suspension, that was, according to the chief, a letter issued automatically by the licensing system based on the restraining order having been issued. And the chief testifies, when that happens, we look behind the restraining order. We always look at the affidavit to see if there's more.
Sure.
That's what happened here. Is the chief precluded from then saying, hey, not only are you disqualified by the issuance of the restraining order and the pendency of the restraining order, you are also an unsuitable person based on the information in the underlying affidavit?
Well, first off, that didn't happen here. There's nothing here that said that he was disqualified, that you have a active restraining order. It was all based on suitability.
I don't think so. What
They
did the
said you
initial
are an
suspension
unsuitable
letter
person.
say?
You know,
You've been suspended because you're currently the subject of a permanent or temporary protection order issued under 209A or an order under 18 U.S.C., so on and so forth. That doesn't sound like a suitability determination. That sounds like a disqualification because of the pending
But they
restraining order.
didn't say that in the notice, Your Honor. They said suitability.
Where did they say suitability in the initial notice?
Regardless, they suspended his license. They didn't revoke it.
And you can't suspend a license based on a disqualification while you do further further investigation.
I'm sorry, I don't mean this flippantly. This was done the day after he appealed.
But the problem we have, and it's not your fault because you're a successor counsel,
Yes, Your Honor.
is that if that appeal was of the appeal denial of reinstatement, it's premature. And I know the town came in and explicitly waived any timeliness concerns. But when you file a challenge to someone's action before they've done it, they're going to tell you why they did it after you file the challenge.
But he didn't. That's not what happened here. His LTC, he received the notice that his LTC was, we'll just say, was taken away. Okay? Now, that's another thing.
Well, let me try it again. I mean, again, it's very important that we understand whether you're challenging the suspension or the denial of reinstatement. Because if you're challenging the suspension, you lose, because the suspension's fine. If you're challenging the denial of the reinstatement, well, then we have to figure that out.
Okay.
But on the other hand, I don't see how you can complain that, hey, I managed to file this thing while they still had time to decide whether to reinstate, and they didn't tell me. You just managed to beat out with the lawsuit before they told you, when they were within time, on whether they wanted to reinstate. And that's why it's important to know which of these two things you're challenging. You keep switching.
What I would say is the suspension, okay, that, or whatever we want to call it, was extant at the time that the order was active. The order was active for roughly 48 hours, approximately. So what counsel did...
It seems to me that the order was active until she didn't show up at the hearing in January, so that was more like 10 days.
Well,
that time period may not be material, but I just want to be clear on what the facts are.
No, I believe that it was terminated in roughly 2 days.
No.
So, because part of counsel's argument was, look, my client never had the opportunity to even challenge this because there had never been a permanent, for lack of a better term, a permanent hearing vis-a-vis.
He could have shown up at the January 5th hearing, although I'm not sure what the point of that would have been when the plaintiff wasn't going to continue it.
Well, sure. But I mean, the fact is, that's how it panned out. His point was, I think, counsel's point was, that under the statute and the case law, it says the only way you can challenge a suspension, a licensing action, if it's based on a pending active 209A restraining order, the only way you can challenge that is in the 209A order hearing itself, and he never had that opportunity to do it. I know counsel pushed that. I should say advance that theory, that argument.
Can I come at the problem a slightly different way? Suppose that a person applies for a license and a license to carry, and they disclose on their application that they recently had a restraining order issued against them, but it's been vacated by the court, or it's lapsed because the plaintiff didn't show up at a hearing to continue it. So that's no longer a disqualification because it's no longer a mandatory disqualifying factor. Can the licensing authority nevertheless look at the facts underlying the issuance of that order, and specifically the plaintiff's affidavit, and decide that the applicant is unsuitable?
Well, I would preface what I'm about to say by, it violates Bruin.
Right, okay. Assuming arguendo, the constitutionality of the suitability standard, is that a permissible application of it?
But I think if that's going to happen, I think it should be reflected in the suspension notice.
I'm asking you if it's a permissible application. Is this information that's in the affidavit sufficient for a licensing authority to determine that the person is unsuitable?
I mean, I suppose under the existing mass law, yes, but I would suggest Bruin invalidates all of that. I would suggest Rahimi is actually very, very instructive in that regard, because it only deals with active orders. And the court pointed out, the U.S. Supreme Court pointed out in Rahimi, that it's an active order, prior judicial determination of dangerousness that is put into an active order, and that it's temporary in nature. And that's not the case here. Suspension in Massachusetts, completely open-ended.
So your argument of, your interpretation of Rahimi is that it only upholds this kind of determination with respect to an active order, and then once the order is terminated for whatever reason, then what would, is that your reading of Rahimi? Or?
Yes, Your Honor. In fact, the court pointed that fact out, pointed out that, look, it's by definition, it's only temporary. And that's not the case here, what we have here in Massachusetts.
Okay.
All right, thank you for your argument.
Thank you.
And we will hear from the police chief, Ms. Harris-Parks.
Thank you, Your Honors, and may it please the court, Madison Harris-Parks for the appellee, the former chief of police of Norwood, William G. Brooks, and I am joined by my colleague, attorney David DeLuca, who handled this matter at the lower levels. Your Honors, the question before you today has been muddled by the recent and rapid changes that have taken place in our licensing laws since the time of the chief's decision back in 2021. In particular, the August 2022 amendments to the statute, the governing licensing statute, addressing any constitutional concerns that were raised by Bruin. The amended statute, which my brother today asks this court to find unconstitutional, was not in place at the time of the chief's decision, and it would be inappropriate for the court today to address constitutional arguments that were neither raised below.
Why do you think he's asking us to strike down the current system rather than the one that existed in 2020? 2021.
Looking at the brief submitted by the appellant, it references specifically the current statute, at least to the extent that the current statute is what is appended.
He put the current statute in his addendum, as did you, but he seemed to quote the old statute every time he quoted the statute.
Yes, but I think there was no specification by the appellant in raising this constitutional argument that he is asking the court today to deem unconstitutional the statute as it stood at that time prior to Bruin, and instead asks the court today to find the statute completely facially unconstitutional.
But in any event, we need to apply the statute as it stood at the time of the chief's action. Is that your position?
Correct.
All right.
Which is unfortunate because that statute is definitely unconstitutional, right?
To a certain extent. So looking at Bruin, it invalidated specifically the good reason standard, which was contained in that statute, and then in August of 2022 taken out by the legislature, as well as parts of the statute which gave certain deference to the licensing authority to, the difference between may and shall in terms of deciding to suspend or revoke. But I would say the important aspects of the statute as it stood specific to unsuitability was not something that was overturned by Bruin and are applicable and controlling here under either statute. So the extent to which the licensing authority was required to make a determination of unsuitability upon the occurrence of a change in circumstances after allowing the license initially. And that determination is required under both versions of the statute, that unsuitability shall be determined based on a finding of, or based upon reliable and credible information, and that's what the district court credited here.
I have a question about what the district court relied upon. Yes. Do you read her decision as relying on the totality of the plaintiff's history or only on the December 2020 incident?
So the looking at the license, or looking at the district court's determination, it credited the public safety concerns that were specifically raised by the affidavit submitted and the chief's weight that was given to that affidavit and the concerns that were raised there. So not just the suspension under the 209A order, but also the consideration of the chief thereafter of the affidavit and the underlying facts of the 209A order.
And I don't see the district court talking about the prior incidents with the plaintiff that are reflected in the record.
No. So at the district court level, it was a request by the appellant to have those prior orders not considered by the court. It was determined and found at the end of that hearing that the motion to not allow those in was denied by the district court.
She allowed them into evidence de bene, I think, following a prior ruling.
Correct.
But it doesn't look like the district court judge actually discussed those or relied on it in affirming the chief. She seemed to say that his testimony and the information in the affidavit provided a reasonable ground for not reinstating.
Correct. The review.
Is that by itself sufficient?
Yes, I would say so. The review of the district court was to find whether or not the police chief had any reasonable ground upon which to make his decision to suspend the license or continue the suspension of the license. And the chief gave great weight to the affidavit, which, if you look at the affidavit, says it points to the appellant's history of abuse as well as a very present danger of harm. The appellant's wife spoke to a incident of physical abuse just the night prior to submitting the affidavit. And so I think to my brother's point about preclusion and issues with this totality of the circumstances of the history of abuse, I think the affidavit creates a change in circumstances and brings a new weight to that prior history of abuse that perhaps was not as heavy or as considered given the timing at the time of the appellant's application for the license to carry. But certainly the issuance of the 209A protective order and the affidavit that was in support of that and allowed for the 209A order to be issued ex parte was certainly ample justification for the police chief to suspend the license even after the 209A protective order was dropped. I would also I guess, again, speaking to the district court, specifically crediting the public safety concerns that were raised within that affidavit. And so, again, speaking to that totality of circumstances at the time of the chief's decision and with this new information. And the licensing statute, as written either before or after the amendment, requires the police chief to make supplemental determinations of suitability even after a license has been granted. So the appellant's reading that the police chief would be precluded from ever making a reconsideration of a prior grant of a license would be completely inconsistent with the statute. I would also just say, to the extent that the constitutional arguments have been raised today regarding the constitutionality of the governing statute here, I would point to my brief and the waiver arguments. The appellant had every opportunity, to the extent that he has said that Bruin invalidates the prior licensing or the prior statute. He had every opportunity before the hearing and before the issuance of a decision by the Superior Court to raise those arguments. That was not an argument that was ever raised at that time and should not now be considered when the record was not properly developed below for considerations, these very important questions of constitutionality. And then I would point as well just to the letter that was submitted by the Attorney General's office, which similarly speaks to the importance of the Attorney General being able to intervene at an appropriate time to defend the laws of Massachusetts, something that was not.
Yeah, well, someone's going to have to decide whether the new scheme comports with Bruin and Rahimi. I assume someone's doing that. But you may have Mr. Perdomo back under the new scheme with a good claim.
Absolutely. And I would just point to, I think, my brother noted that even today, the appellant's license has not been reinstated, but there is nothing in the licensing statute that prohibits the appellant even today from asking for reinstatement. His license has not yet expired. It goes for about 6 years. It was issued in 2019. Today, he could ask the new police chief for reinstatement, particularly given any changes in circumstances in his marital relationships. And so to the extent that this suspension has continued, I don't think is properly before this court, as the question remains just as to the justification of the chief at the time of his decision.
All right.
All right.
See no further questions. Thank you for your argument.
Thank
you
you
both. And this concludes our session for today. I want to thank our court officers, our clerk's office staff, and our law clerks for their assistance. And we will be in recess. We will be back out shortly to talk to the summer interns who are here.